What happened when you logged into Judge Meconico's courtroom?
It keeps sending me a message telling me that my name has to be on display. He keeps sending me a message and my name is on display every time and it won't let me in.
All right, give me 1 second. I'll give you the phone number to that courtroom.
Okay, thank you.
All right.
Good morning. You okay? Martin is just like.
Good morning. This is Attorney Hart checking in.
Hi, Mr. Hart.
You're on Elliott?
Yep, on Elliott. We're going to need a quick breakout room with the, I think it's the Attorney General's office that has this.
You need a breakout room with the Attorney General or with your client?
No, I talked to my client. I need one with the Attorney General.
Oh, is he here? He or she? Whenever they get here, I'll put you in there. Okay, Mr. Hart?
Appreciate it, Judge. Thanks.
You're welcome.
Is it Javante?
Yes, sir.
Okay, that phone number is 313
Yeah.
965 3953.
Thank you, sir.
Okay. You ready?
Yeah.
Okay. Calling parties on Demetrius Ryan. I'm sorry, Demetrius. Whoa. Calling parties on Ryan Minner. Calling case number 21-59211. People versus Ryan Demetrius Minner. Defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, carrying a concealed weapon. Count 3, weapons from the firearm. Count 4, controlled substance, possession of cocaine, heroin, or another narcotic less than 25 grams. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for a probable cause conference.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Rima OPP 82800 on behalf of the people.
Good morning. Defense counsel?
Mr. Craig.
This was the script you was just on. You call it something else?
Yes, please.
Okay. Okay. Calling person Gail Haywood. Calling case number 21-5227. People versus Miguel Malik Haywood. Defendant is charged with 1 count. Police officer assaulting, resisting, or obstructing. Defendant is scheduled today for a probable cause conference.
Thank you, sir. Appearances, please.
Good morning, Your Honor. Rima OPP on behalf of the people.
Hey, good morning, Your Honor. Catherine O'Mara, P53823 on behalf of Mr. Haywood.
Good morning. Is Mr. Haywood here?
He is. Yes.
Please say your name.
Nigel Haywood.
Wait, say it one more time.
Nigel Haywood.
Okay, good morning. Today is the date and time set for PCC. Madam Defense, what's your pleasure here today?
Your Honor, I've only received the video discovery on this case. I haven't received the paper discovery. So either set it for a preliminary exam or for an adjourned PCC so I can get the discovery. I don't know what the court prefers to do in this situation.
Well, you know, the exam dates are so far off that you're going to have plenty of time to remedy any discovery issues.
Okay.
So I would setting it for an exam. And in the interim, if you find that you're not getting the paper discovery, then you can notify the court to tee it up for a motion.
Okay, thank you. So
Okay,
just
Ms.
an exam date.
Ms. Yafufi, can we ensure that that discovery gets to her?
Yes, Your Honor. I'll do it today.
All right, so the exam date I think Madam Clerk last, when she was setting exam dates for this sort of an offense, non-custodial was in December, Mr. Clerk.
Okay. December 20th at 9:30.
December 20th at 9:30,
That's a good date for me, Your Honor. Thank you.
close to Christmas. Okay, December 20th at 9:30 in the morning, in-person examination. Is there anything further?
Nothing for defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Haywood. Please make sure you mark your calendar and you plan to be present in the courthouse on the date that we just indicated, okay?
Is,
Thank
when
you.
was it, December 20th?
December 20th, 9:30. I will text it to you.
All right.
Calling parties on Anthony Collins. Calling case number 21-59229, People versus Anthony Benjamin Collins. Defendant is charged with count 1, police officer assaulting, resisting, or obstructing, causing injury. Count 2, police officer assaulting, resisting, or obstructing. Defendant is not a habitual offender. Second offense notice. Defendant is scheduled today for a probable cause conference.
Thank you, sir. Appearances, please.
Good morning, Your Honor. Rima Haruki on behalf of the people.
Yeah, good morning.
Your Honor.
Who's that?
Good morning, Your Honor. Ronald Debo, P63897 on behalf of Anthony Benjamin Collins, who I believe is here.
Okay, Mr. Collins, can you please state your name?
Anthony Collins.
All right, counsel, what's your pleasure?
We wish to waive the preliminary exam and have this matter be bound over.
Are there any objections to the proposed waiver, Madam Prosecutor?
No objection, Your Honor.
Okay, Mr. Collins, I just have a few questions for you. Sir, do you understand the allegations against you?
Yes, ma'am.
Do you understand that you do have a right to a examination?
Yes, ma'am.
Do you understand that if an examination were to occur, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those offenses? Do you understand that?
Yes, ma'am.
And if the prosecutor at an exam were able to establish that burden, then the matter would be bound over to the circuit court. Do you understand that process, sir?
Yes, ma'am.
Thank you. So with the representation that's been made here by your attorney, you wish to give up your right to a preliminary examination. Is that true?
Yes, ma'am.
Do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes, ma'am.
And again, is that what you still wish to do? I'm sorry, your answer was what?
Yes.
And are you doing so voluntarily, sir?
Excuse me, I didn't hear you.
Are you doing so voluntarily on your own without threat or coercion?
Yes.
Thank you. So with that being said, I do find your waiver to be knowingly and voluntarily given. The matter will be bound over to the circuit court for further proceedings with an AOI, an arraignment on information date of August 9th. I believe that's right. Is that right, Mr. Clark?
Is it 3 weeks out?
It used to be 2 before the pandemic, and it's shifted to 3, so. Yes, is that right?
Yes, ma'am. That's correct.
Today is the 19th, yeah. August 9th at 9 a.m.
Thank
Or
you,
did
Your
they
Honor.
shift? Mr. Clark, have they shifted back to 2?
I can double check.
Yeah, can you double check?
Yeah, I
I'm
can
just
double check.
assuming that.
Fine.
If they did, I missed that. Keep your device.
Are the arraignment information days still? Okay. Okay.
Well, I've got this moment before the clerk calls the next case. For those of you that are new to Zoom, welcome. Please make sure that you act in accordance with how you would inside of an actual courtroom. That would include that you would be clothed, that you be wearing clothes, that you be properly clothed, that you refrain from any profanity, and that you would just generally act, again, as you would if you were actually inside of a courtroom. Also, if you are speaking, if you're the defendant or an attorney, please make sure that not only your audio is going, but that your video is also rolling. I see there's one individual with a very dark screen. I see them kind of moving about. Make sure that the video is such that we can actually see who it is that we're speaking to. It would also be helpful if you could name your device. You have the capability to rename your device from, say, iPhone to your actual name. That would be helpful so you're not sitting there all morning and we don't know if you're there for your matter. So next, oh, Mr. Attorney General?
I'll be ready to tell you. Yeah. Mr. Hayes.
I'm gonna put you in a breakout room with Mr. Hart. Is Mr. Hart still here?
There he is. He's here.
We're here, Judge. Hey, Judge, if I might,
Yes.
I've already had communication with Mr. Hayes.
Oh,
We're just going to be asking for an adjournment of the PCC so I can see a video.
I see, thank you.
Right.
Yeah.
Calling parties on Jacqueline Jones. Calling case number 21-59227. People versus Jacqueline Renee Jones. Defendant is served for count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
APA Bloomers is on his way to the courthouse then.
Okay, can you pass on?
Calling parties on Clinton Horton. Calling case number 21-59369. People versus Quentin Martez Horton. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons found in firearm. Count 3, domestic violence. Defendant is scheduled today for a probable cause conference.
Thank you, sir. Appearances, please.
Your Honor, that's also a DD case.
When you say also a DD case, the one before was Slusky.
Was it?
Well, that's what I heard you say, that Slusky was on his way.
Or APA Bloomers.
She said Bloomers.
Oh, okay. So
Yeah, I called him.
he's on his, it looks like that might be him there. No, it isn't.
I thought he was on.
Okay, next case.
Your Honor, we are ready on that motion now.
I didn't hear what she said.
She said that they're ready.
On the motion? Is that the motion?
I believe so.
You ready?
I mean, I don't know. I'm assuming that's what she's on. I don't know for sure.
Are you on the motion, Madam Prosecutor?
I'm sorry. Yes, Your Honor. This is Lori Morales, APA Lori Morales Smith. All three parties are ready on the motion.
Okay, they were actually next to me. Calling parties on Joseph Johnson and Brittany Chavis. Calling case number 21-58920. People versus Joseph Richard Johnson and Brittany Sada Chavis. Both defendants are charged with count 1 and 2, assault with intent to murder. Counts 3 and 4, assault with intent to do great bodily harm, less than murder by strangulation. Counts 5, 6, 7, and 8, weapons from the firearm. Defendant 1 is a habitual offender. Second offense notice. Both defendants are scheduled today for a motion hearing.
Thank you. Appearances, please.
Lori Morales Smith, PA 353 for the people, Your Honor.
Hey, please, the court, John Royal, appearing as attorney of record for Brittany Chavoy, who's present on the Zoom.
Hey, please, the court, Your Honor. My name is Adam Clements, P number 77233, appearing on behalf of defendant Johnson, Your Honor.
Thank you. But I'm sorry, who was counsel for Chavoy?
John Royal, Your Honor.
Oh, okay, thank you. Today, I get scheduled for a motion hearing. What are we doing here today?
Your Honor, I'd like to make sure first that the court has the correct motion. There were actually two motions.
Before you begin, I'm sorry, I'm remiss. I was a little distracted. Could I have Mr. Johnson and Mr. Chavoy put their appearance on? And if they're not here, please know I don't know. I have no idea. I need to know. if
Alicia
you're going
Voice
to-
is here.
I
Joseph
need to
Johnson
know-
is here.
Okay. Let me know what you want to do here today.
Your Honor, it's my understanding that the defense attorneys have put forth motions to have the bond amendment amended for some travel, and I just want to speak out against the allowing of.
Okay, your audio's dipping, so in order for us to understand and for Madam Court Reporter to get your words, you need to repeat what you just said. Please mute your microphones if you're not on this case.
Your Honor, I'd like to
Morales.
make sure
Morales.
the court has the proper motion. There were actually two motions filed. One was the
I
substantive.
don't know if you can hear me or not, but what Ms. Morales Smith said needs to be repeated. We did not hear the fullness of what she said. We have to make a record. That's why we have Madam Court Reporter here. So if we lose the third and the sixth and the ninth word, we don't have a record.
Understood.
Ms. Morales.
I had just said that I believe the defense put forth a motion to have the bond amended for travel, and I'm just here to speak out against that. And I believe Mr. Royal just wants to make sure we have the right motions in front of the court.
Okay. Mr. Johnson, if that's you, I need you, if you're going to be a party to this, I need you to stop driving while you're on Zoom. You can pull over.
I'm actually dropping my daughter off at daycare right now.
Okay, so I think we're gonna pass on this matter. Can you call the next case, please?
Well, he can. Judge,
I do not want him zooming
I can
while,
pull over. I can pull over.
this is not very complicated. Please call the next case.
Calling parties on Elmer Elliott. Calling case number 1957458, People versus Elmer Elliott. Defendant is charged with one count, malicious destruction of personal property, $1,000 or more, but less than $20,000. Defendant is scheduled today for a probable cause count.
Thank you. Appearances, please.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69006.
Good morning, Your Honor. Mark Hart appearing on behalf of Mr. Elliott. Mr. Elliott is on Zoom, and we have no objection to appearing via Zoom.
Thank you. Sir, could you please state your name?
Elmer Ward Elliott, ma'am.
Thank you. Counsel, what's your pleasure?
Judge, we're asking for an adjournment of the PCC. There's a video that I need to take a look at before we can proceed. So if we could have 2 or 3 weeks, I think the likelihood is we'll be able to resolve the matter then.
Okay, what about the August 16th?
It's a good date, Judge.
Good for the people, Your Honor.
New PCC, August 16th at 8:30 via Zoom. So Mr. Elliott, please zoom in on that date just as you did today.
Yes, ma'am.
Any concerns with bond?
No, Your Honor.
Okay, bond will continue.
Thank you, Your Honor.
Thank you, ma'am.
Thank you, Judge. Have a great day. Take care.
Calling parties on Daryl Thomas. Calling case number 2156704, People versus Daryl Andre Thomas. Defendant is charged with one count, controlled substance, delivery or manufacture, ecstasy or MDMA, second or subsequent offense notice. Defendant is a habitual offender, fourth offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Max Luffy on behalf of the people.
Counsel, I'm gonna hand it back.
Mr. Dwellers on? Because I think everything else is from Mr. Dwellers. Everything else we have ready is DV.
Okay, apparently there's nothing ready to call. Madam Court Reporter, did you want to take a 5-minute recess? Thank you.
Good morning, Judge. I'm ready on Ms. Jones.
Oh, good morning, Ms. Woodside. Is that a domestic violence case?
Mhm.
Oh,
Good
we
morning,
need,
Your Honor.
we need the DV prosecutor.
Okay, sorry.
No, that's okay. Thanks for letting me know you're here. I'll recall Royal as soon as, the gentleman stops driving. For anyone that doesn't understand, meaning his attorney, that doesn't understand why I would do that, he's dropping off his child at daycare. He's driving. Certainly, I'm not going to proceed with the Zoom hearing that he's a party to while he's driving. I don't understand why that was confusing. We can see the little girl in the back. I mean, I'm not gonna proceed and something happened.
I'm pulling over right now, Judge.
Are there any attorneys that needs to check in while we have a minute?
Oh, good morning. This is Robin McCoy checking in on Robert Ewell. Was set for an exam. He's going to waive on both cases.
Oh, great, let's do that one.
Okay.
Mr. Wright, they're about to call my case. I'm going to call you.
Calling parties on Robert Ewell. Calling case number 2058091, People versus Robert. Calling case number 2058091, People versus Robert Hakeem Ewell. Defendant is charged with count 1, first-degree arson. Also calling case number 2056523, People versus Robert Hakeem Ewell. Defendant is charged with 1 count, false report or threat of a bomb or harmful device. Defendant is scheduled today for examinations on both matters.
Thank you. Appearances, please.
Good morning, Your Honor. Remash Rufi on behalf of the people.
And good morning, Your Honor. Robin McCoy on behalf of Mr. Robert Ewell. My P number is 63057. We have no objection to appearing via Zoom in light of the COVID pandemic.
Okay, could you please state your name, Mr. Ewell?
Robert Hakeem Ewell.
What is your pleasure here today, Madam? Mr. Ewell, please mute your microphone because you've got a lot of background noise. Thank
Yeah,
you.
I don't know if he might be at work right now, but yeah. So I did have the opportunity to talk to Mr. Ewell about these 2 cases. We've gone over the discovery. This is a case too where we had a criminal responsibility and competency, and they came back with a result for criminal responsibility that he was legally insane at the time of the incidents. But at this time, we're opting to waive both exams. Mr. Ewell's opting to do that and have this go forward to the circuit court. Mr. Ewell, the judge is going to ask you some questions about that.
Understood.
Okay, based on what you just said, I don't know if perhaps the notes in my file are not updated. Is it your understanding that there was a stipulation to the findings of the evaluation?
Yeah, we did that I thought that we did that at the last hearing because we had a hearing on this. It was set for an exam. Let's see,
I'm not saying it hasn't happened. I'm just saying I don't see that in my notes.
Oh, okay.
The last notation I have is from March 15th. Madam Prosecutor, what's your understanding to that degree? If so, if it has not happened, there needs to be, well, you need to let me know if you're stipulating to the findings. We can't just bypass that step.
Yeah, we would stipulate to the findings for competency and criminal responsibility, Your Honor.
And I did read the comp report, Your Honor, and they did find the defendant legally insane at the time of the offense.
Okay, so your desire, as opposed to waiting, oh, okay, all right.
Oh, and it's 2 offenses because he's got 2 separate cases. He's got the firebombing and the arson.
Okay. Yeah, I don't think that that language, that was ever placed on the record. So prosecution and defense, from what I'm hearing now, are both stipulating to the findings of the evaluation from the Forensic Center. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
And as opposed to anything else, you're seeking to move forward to circuit court to have it resolved there?
That's correct. I did talk with the prosecution about this. They said that there's presently no offer, but that we'd obviously talk about that further at the circuit court level.
All right, so let me ask, Madam Prosecutor, is there any objection to the proposed waivers on these files?
No objection, Your Honor.
Mr. Ewell, do you understand the allegations against you, sir?
Yes, I do, Your Honor.
Do you understand that you have a right to a preliminary examination?
Yes, I do.
Do you understand that if an examination did occur, that the prosecutor would need to establish by probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes?
Yes.
And if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court. Do you understand that process?
Yes, I do.
And the representation made here by your attorney is that you wish to waive your right to an examination, give up your right to an examination. Is that true?
Correct.
And are you doing so voluntarily, sir?
Yes.
And you understand that that would mean that this matter would automatically be bound over to the circuit court for further proceedings without an examination?
Yes, I understand.
Okay. I do find your waiver to be knowingly and voluntarily given. The only thing we're missing, Madam Defense, are the examination waiver forms that I need to be executed by yourself. And if your client gives you permission, something does need to be filled in where their name is. If you've already done that and returned it to Mr. Clerk, that's great. But if not, he's going to need to forward that to you. That needs to be returned to the court by the end of the morning. We cannot process the waivers without that paperwork completed.
Okay, should I just provide my email now or?
Yes, please.
Okay, so I'll give you the newest email. Well, it's in the bar journal. So Robin Legal, so it's ROBYN legal LEGAL 2019@gmail.com.
Okay, the waiver again, for the record, is accepted. I do find it to be knowingly and voluntarily given. The AOI date is going to be August 9th at 9 a.m., given the fact that your client is not in custody.
Okay, and then we'll get 2 waivers because this is 2 cases. So yeah, I'll look out for that, and then I'll go ahead and go over that with my client as well.
Okay, thank you so much. We're all set.
All right, thank you, Your Honor. Hope that you all stay safe.
You too.
Thank you.
You're welcome.
Calling parties on Daryl Thomas. Recalling case number 21-56704, People versus Daryl Andre Thomas. Defendant is charged with 1 count, controlled substance, delivery or manufacture, ecstasy or MDMA, second or subsequent offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Remash Goofy on behalf of the people.
Morning, Your Honor. Matthew Gatona, legal intern with Neighborhood Defender Service. I respectfully request this court allows me to practice law pursuant to Michigan Court Rule 8.120. Attorney Emily Elijah is in the room and I'm under her supervision.
I'm sorry, attorney who?
Emily Elijah.
Emily who?
Emily Elijah, Your Honor. ELIJAA.
And your P number?
P number 85039, and we're standing in on behalf of Miss Jackie Pukalowitz.
Okay, so granted. Your client. Is your client present? If so, could they please state their name?
New President, Mr. Thomas.
Mr. Clerk.
Ma'am.
So on this one, they both, prosecution stipulated the findings of the evaluation, and there's some additional paperwork that needs to be done in that regard, or maybe not, but I just wanted to let you know, it wasn't just a waiver, but that substantive information needs to also be included somewhere.
I will.
You know, usually it'll be a finding of, you know, what I'm saying.
Okay.
Mr. Thomas, are you present? Mr. Darrell Thomas. Well, what's going on? Did you want me, are you requesting to waive?
Move to waive his presence, please, Your Honor.
Yes, their presence will be waived for purposes of this proceeding. What's your pleasure?
We still need digital discovery, and we would also like to set a preliminary examination date, Your Honor.
Okay, Madam Prosecutor, can you ensure that any digital discovery gets forwarded to whom? Ms. Pilkowitz?
Yes.
It's in the works, Your Honor.
Okay, I don't know if you heard that. She said it's in the works.
Yes.
An examination date is needed and demanded here, so that would be. Hold on. Yes, go ahead. December 20th at 10 a.m.
That works, Your Honor.
Okay, anything further?
That is it, Your Honor.
Okay, thank you so much.
Thank you.
Thank you.
I think that's all we have. Everything else is waiting for Mr. Bloomers again.
Mr. Bloomers is.
Oh, good morning. Okay. Calling parties on Quentin Wharton. Recalling case number 2159369, People versus Quentin Lamartez Horton. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Count 3, domestic violence. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning.
Good morning to this honorable court. Carla Marable, P number 62755, on behalf of Mr. Horton. Mr. Horton, can you please state your full name for the record, sir?
Quentin Horton.
Thank you. And
Your
good
Honor.
morning.
Good morning. Your Honor, this is the probable cause, and I need a discovery on this particular case, and we need to set it for a live preliminary exam.
Bloomers?
Yes, I did send discovery to Janecki Nance, who I believe was the attorney on our way, but I will send it to Ms. Marable straight away, the paper discovery, and then I will follow up with digital.
Okay, and she's demanding an in-person examination. Are there any concerns about the bond that might affect when we set this for an exam?
No, Your Honor, the defendant, I believe, is on a $25,000 10% bond with a GPS tether, and people are satisfied.
Okay. Mr. Clerk, can you find a closer date, somewhere like October?
October, the middle or the?
Yes. Thank you, Your Honor.
You're welcome. I try to keep those sorts of cases closer. The middle?
How about, October 20th at 9:30?
October 20th at 9:30. Would that work for you, Ms. Marable?
That will be fine, Your Honor. Also, Your Honor, I have a new attorney at the firm. He's here, Austin Gregory. He will be doing a lot of my probable cause hearings.
Oh, okay. Pleasure to meet you. Mr. Gregory, can you state your name? Is that you right there?
Mr. Gregory?
You're muted.
Good morning, Your Honor. Thank you.
Good morning. Are you going to be handling this matter, Mr. Gregory?
No, he'll be sitting second chair with me.
Okay. All right. Pleasure to meet you, Mr. Gregory. We'll look forward to working with you.
Thank you.
Ms. Marable, did you have any concerns beyond what we talked about?
No, I'm just waiting for discovery, and you know me, if I don't get discovery, I will zoom back in.
I know you will, and please, you're welcome to do so. The exam date is set far enough out that I'm assuming that any discovery concerns will be remedied. Mr. Bloomers is usually right on top of that. But if there are any outstanding issues as you get closer to the exam, please do notify the court, and we'll set it for a hearing.
And I'm sorry,
Thank you.
Bye-bye. One more time.
The date is October 20th at 9:30, in-person examination.
Thank you.
Yes, in person. Bye-bye.
Okay, thank you.
Calling parties on Jacqueline Jones. Calling case number 21-59224, People versus Jacqueline Jones. Offender is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. Offender is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of people.
Good morning, Your Honor. May I please support Sharon Clark Woodside appearing on behalf of Ms. Jones. Your Honor, we'll set this for an in-person preliminary exam.
Good morning to you, Ms. Woodside. Is your client present?
She is. She's been on. She beat me on this morning.
Oh, fantastic. Please state your name, Ms. Jones.
Ms. Jones?
Jacqueline Jones.
Okay. Today, being a PCC, that defense has demanded an examination. Do you have discovery that you need?
I just received paper discovery now. I don't know if there's any digital discovery, but I do have paper discovery.
Okay, given the fact that this, well, let me ask you, are there any concerns regarding bond, Mr. Bloomers?
No, that's the bond. The defendant is at a personal bond, no contact order. However, based on my contact with the complaining witness, there are no concerns at that bond at the time.
Okay, notwithstanding that, Mr. Clerk, I would like to keep this closer. Do you have an October date you can decide?
Okay. How about October 21st at 9:30?
October 21st at 9:30, Ms. Woodside?
Oh, let's see. I would have to need an afternoon date for that, Judge. An afternoon for that day.
No, we'll give a different date. Is there a different October date?
It has to be.
If it's not Tuesday, then I'm gonna need an afternoon.
Can we give her a Tuesday?
Tuesday, okay. Okay, how about Tuesday the 19th at 9:30?
October 19th at 9:30?
Yes, Judge, that's fine.
The bond will continue?
You did say 9:30, correct?
Yes, ma'am.
Okay. Have a great day, you and your staff.
You too. Ms. Jones, you can log off now.
I'll call you, Ms. Jones.
Thank you, Your Honor. Okay.
Calling parties on Jasmine Clyde. Calling case number 21-59171, People versus Jasmine Marie Clyde. It's charged with count 1, assault with a dangerous weapon, felonious assault. Defendant is scheduled today for a probable cause.
Ms. McCracken, Z40159.
Appearances, please.
Good morning, Your Honor. Rima Kuki on behalf of the people.
Sarah Robinson.
Ms. Robinson, I don't see. Yes. Ms. Robinson, are you there? Doesn't look like she's fully connected. Are we ready to recall the two-bagger?
Your Honor, I do believe the defendant is parked.
Okay.
Yes, I'm parked.
Recall of People versus Joseph Johnson and Brittany Chavoy. This is 210-58920. Can I have appearances, please, as this has already been formally called?
Lamarella Smith, P83353 for the people, Your Honor.
May it please the court, John Royal, bar number P27800, appearing on behalf of Brittany Chavoy, who is on the Zoom.
Thank you. Ms. Chavoy, please state your name.
Brittany Chavoy.
Thank you.
Court, Your Honor, my name is Adam Clemens, P number 77233, appearing on behalf of defendant Johnson. Sir, would you state your name for the record, please?
One more time, Mr. Clements, your audio, Madam Court Reporter can't hear you. Your audio is really low.
Hey, please, the court. My name is Adam Clements, P number 77233, appearing on behalf of defendant Johnson. Would you state your name for the record, please, sir?
Joseph Johnson.
Thank you. That was much better, much clearer. Okay, so the motion, why don't you tell me what you want this court to consider?
Your Honor, I would first want to make sure the court has the correct motion. And the reason for my request is that on Friday, the court inadvertently signed the motion for immediate consideration. There's two motions that were filed simultaneously. One is the substantive motion asking this court to authorize these two defendants to leave the state for 2 weekends on previously planned and paid for vacations and trips. The second motion was the motion for immediate consideration. The motion the court signed on Friday was the motion for immediate consideration. And it's important that the court have the substantive motion because that has attached to it emails from the airlines confirming their travel arrangements.
Okay, yes, I do not have that. That's number one. Number two, when I signed that, I asked whether or not this was stipulated to, signed electronically by the prosecutor. My understanding was that it was, so I quickly signed it. That is not the case according to Madam Prosecutor, and that is why I asked Madam Clerk to alert everyone to zoom in. So I think we just need to start from scratch. If you could indicate what, well, obviously we've heard the nature of the motion, and I'm assuming now, Madam Prosecutor, you have your own copy of it. What is your response, Madam Prosecutor?
Your Honor, the people would like to request the court to deny the travel of the two defendants. There's very serious allegations here. In other circumstances, they wouldn't, it's possible they would not even have been out on bond had I been able to make the arraignment. The charges are, like I said, very serious, but there's also been, the complainant has heard from mutual acquaintances because they all, it's a group of people that are all familiar with each other, that the defendant is telling mutual acquaintances that he's going to air her out. It's a quote from—
That he's going to what? That he's going to what?
Air her out. And it's a quote from the complainant. It's that is what he's going around telling people. Your Honor, she is still not feeling safe to return to her original home. She has found another place to stay during all of this. She went to go do, she has some properties that we put on that protect the addresses that we put on the tether. She was there working and felt that there was people appeared the vehicle going by over and over again that make her feel very uncomfortable that other people, and perhaps it's not Mr. Joseph and Mr. Chavoy themselves, but other people are casing her properties. She still is not feeling safe. And I just, the people feel that it's just not warranted that the defendants have fun while the complainant and her sister are all, and the people that were on their bus are still quite in danger, Your Honor. And that is the basis of our not stipulating to it. They're going to be rewarded for their behavior, be rewarded and have all this fun. And, the complainants and the other people are still not feeling safe.
Your Honor, can I respond, please?
Yes.
The prosecution is ignoring the primary legal principle of our criminal justice system, which that people who are accused of crimes are innocent until proven guilty. The prosecution is in effect asking this court to impose a punishment prior to a finding of guilt. When we were in this court several weeks ago on the prosecution's motion to increase the bond in this case, this court was very concerned about the proceedings in which the magistrate initially authorized bond in this case. And I want to inform the court that although I could not see exactly what the magistrate was doing, The magistrate spent a considerable time reviewing this file, and I assume she was carefully reading the investigator's report. And that's why she set bond the way she did, because the investigator's report reveals that although these charges are serious, the evidence supporting them is extremely weak. It's unclear that they're going to be able to get a bind over in these cases. This is a cell phone location case. The complainants claim that they had an argument with these two defendants at a club at the location of Livernois and Grand River. And they claim that they then took their group and got into a bus and were driving down Grand River. At the approximate location of Grand River and Joy, there were shots fired at the rear of their bus. Their evidence is cell phone location. But these two locations, the club and the shooting site, are very close together. And I don't believe the prosecution is going to be able to prove that their cell phone location data can distinguish between someone who's at Grand River and Livernois and someone who's at Grand River and Joy. So I don't think they're going to be able to establish probable cause in these cases. And I think it's important for this court to keep in mind that the purpose of bond is to ensure that the defendants appear as directed and that they're not a danger to the community. In this case, the prosecution has presented no evidence that they're a danger of community other than unsubstantiated allegations. They haven't submitted any reports of these supposed threats, any statements, any evidence. This is all hearsay. In addition, I would indicate that these defendants have acted very seriously in confronting these accusations. As soon as they found out about them, they promptly retained counsel, which is a serious investment in the outcome of this litigation. And I arranged through a sergeant with the Fugitive Apprehension Unit of the Detroit Police Department to surrender these two defendants promptly at the Detroit Detention Center. They both turned themselves in, and the magistrate took all that into consideration in setting bond in this case. This court increased the conditions of bond by requiring both defendants to wear tethers. They promptly went to the jail, got it submitted with tethers. My understanding is that the jail does not want people to wear their tethers out of state. So these defendants had previously, before these charges came up, had made arrangements to take a honeymoon. They just got married, to take a honeymoon from July 23rd to July 25th. And they're going on a family trip for the birthday of one of their sons to Myrtle Beach, South Carolina from August 5th to August 9th. I prepared an order granting these motions that authorizes them to go to the county jail the day before they leave and the day after they return to have the tethers removed and put back on. They are taking this matter very seriously, and if the prosecution is concerned about the well-being of the complaining witnesses, then it seems to me that should be supporting this motion, because to have these defendants a far distance away from Detroit helps deal with the complainant's fears. So we think this motion is certainly reasonable. It's not submitted, it's submitted in complete good faith, and we ask the court to grant it. Thank you.
Did you want to add anything before I speak on it, Mr. Clements? I just don't want to get started and you say, wait a second.
Yes, just very briefly, and obviously I would adopt the arguments made by brother counsel in this particular matter, so I won't be redundant. But what I would also like to add in this particular case, of course, we'd ask the court to consider that there's a 5-month lag time, almost 6 months between when the incident took place and when the actual charges came down in this particular matter. And I think that that's important for the court to consider, because the defendants have always remained here and they've always been in the general vicinity. They've never fled, they've never vacated. And you know, Mr. Royal is 100% accurate. All we can do is evaluate behavior that they demonstrated from the date that the incident took place up until now, and it's been 100% compliant, 100% suggested that they'll continue to comply with any orders the court puts in place. I think to punish them for simply being charged is a pre-adjudication of guilt, that they should lose their trip, that they should lose money, that they should be penalized before we've even had an opportunity to put forth the proofs in this particular case. So I think that based upon the conduct that they've demonstrated, they've shown that they can be trustworthy and the court can trust them to return to court and to be compliant. And I agree with brother counsel, if they're out of state, then certainly that alleviates any concerns about them coming into contact with the complainants. And as Ms. Morales has stated, our clients don't even know where these complainants live. So If they vacated a particular address and are staying somewhere else, I don't know how any threats or any harm could be attributable to either Mr. Johnson or Ms. Jaboy. And for those reasons, I'm asking that the motion be granted.
Okay, Mr. Royal, I just don't want to get started. You look like you were leaning forward. I don't want to get started and somebody say, wait. Can I make my determination? Oh, yeah, yes, Ms. Morales-Smith.
Just to briefly respond to a couple of the things that both councils brought up. One, in this particular manner, there was a long investigation to get cell phone data, to get other things in the area. Two, without going into detail, we have further evidence that ties these people to the crime committed beyond just the cell phone evidence. And three, Your Honor, you are well aware of the backlog in our office for COVID and everything else. That was the reasons for the delay. There was the case has been being worked on since it happened. It took a long time to catch up to that. We would ask that with those three things, and I just wanted to respond to those three things, Your Honor, sorry.
Mr. Clements, I see your frown. I don't want to, you want to respond?
No, I was just going to say we disagree. That's it.
Okay.
Vehemently.
All right. So it is not a penalty that is being imposed when the inability to leave the state is one of the, well, it's a standard. It's pretty much a standard requirement. That's not a penalty when there's a, that the defendants are facing. In this case, the defendants are each facing 8 felonies. Stopping, if you want to just start at the top of the line, the 2 counts at the top of the complaint are life charges. And then it trickles on down. And again, I will state, an inability, a restriction upon leaving the state. It's not a penalty that this court is imposing, or that I'm not imposing. It was already in place. It's in place for all people, all individuals facing. If they want to travel, they need to get permission. This case is no different. That is why the motion was made. And notwithstanding the strong arguments by both defense counsel, again, I signed this. I readily signed it on Friday because I thought Madam Prosecutor was on board and had stipulated and had electronically added her signature. That was the only reason why I readily signed it, because as all the parties here know, I don't do a whole lot of anything unless all parties are here and on the record, if at the very least on Zoom. But when there's an electronic signature or a real signature, and there's a stipulation, I do sign documents. Again, I want to be clear, that is the only reason why I readily signed that motion. The defendants, whether you like what the state has charged or not, are now each facing 8 counts that are all very serious. I am going to deny the motion. It would not be proper to, under these circumstances, allow travel. Now, Mr. Clements is smiling as if I've cracked a joke. This is, listen, at the end of the day, I have to make a determination. Half the people are upset with it, half the people are not. But while your clients are in front of the Zoom gallery right now, there's a whole nother side to this. There's a flip side. And that's part of my responsibility when I zip up my robe and come in here, is to make a determination about what is appropriate. Some really bad things happened on this particular day. Now the prosecutor is going to be left to their proofs. I'm not imposing a penalty. I am not imposing a penalty. And it's important that your clients understand that. The inability to travel out of state when you're facing a felony, let alone 8 felonies, is not a penalty that I am imposing. And I am going to deny, based on the representations that have been made here, the motion. I know that it's been articulated that it's a honeymoon and a birthday trip. I get that. But these are really serious allegations. And I am not going to acquiesce to a removal of the tether for both defendants, to travel out of town, not once but twice, even considering the nature of the trips being a honeymoon and a birthday for their child. So I'm hoping that there is going to come an opportunity for the defense counsel to each explain to their respective clients the position that I'm in. It's not personal, nor is it meant to be a penalty. I treat every case the same, in the same way that if either Mr. Johnson or Ms. Chavoy were the complaining witness. The same deference. It is not a penalty in imposing the restriction, and it's not a penalty in denying the motion. The motion is hereby denied for travel. I'm trying to be very clear, and I'm trying to explain a fullness. I think that's always helpful, to explain the why behind it. That's what I do with most things. So I understand that it's not met with happiness, but that is the determination of the court. We will see everyone on August, I think it's 24th, for the in-person examination. Oftentimes what I do when I'm denying a motion like this is I bring that exam date closer. But we can't do that. We can't do it because our docket is spilling over. Those were the first dates that we could carve out, even though your clients are not in custody. I gave August dates, which is unheard of. July 2nd, I gave an August date, 2 August dates, the 24th and the 26th, because of the nature of the allegations. So we will see everyone on those dates. If I could bring it closer, I would, but I can't. There's just no space. And I thank everyone for their patience today.
I would ask that the court sign the order that I've prepared. I'll send it to, I was going to send it to Tammy, but I can send it to another email address. I had just prepared an order denying the motion.
Oh, yes, if you could, send it to Mr. Sanders, whose email is.
I have
Got
it.
it, okay.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir.
You ready?
Yes.
Calling parties on Latoya Brewer. Calling case number 21-56064, People versus Latoya Joyce Brewer. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with a dangerous weapon for felonious assault. Counts 3 and 4, weapons, felony, firearms. Defendant is scheduled today for a examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Okay, so it's a really good idea if you mute your microphones if you're doing personal business. Just a thought.
Good morning, Judge.
Wait, I'm sorry, wait. I don't have it. This is an in-person examination. Okay, appearances, please.
Jacob Bloomers on behalf of the people.
And Lauren Anderson, P85191 on behalf of Ms. Brewer, who is present.
And please state your name. Antonio Brewer. Thank you. Are we proceeding to an examination?
Your Honor, at this time, the complaining witness, Antonio Brewer, is not present in the courthouse. He was subpoenaed to be here for a 9:30 preliminary exam. Without his presence and participation, people are unable to go forward at this time.
Is there a motion?
Yes, Your Honor, at this time we will move to dismiss.
Okay, it is currently 10:01. This matter was set for 9:30 in the morning, and the prosecution has represented that they are unable to proceed. I am going to grant that motion to dismiss. The matter is hereby dismissed without prejudice. And that trailer language that follows the word dismissal, what that means is that it is possible that the prosecution can reissue in this matter. If you have questions about the fullness of that concept, please make sure you speak with your attorney and she'll explain it to you in greater detail. Ms. Brewer, do you have on a GPS tether that needs to be removed?
Yes.
I'm going to add that language onto the order of dismissal. It was imposed as a result of this case.
Yes.
We will also alert the tether unit from our angle, but it's always good to have this copy with you when you go to the tether unit, so there's no confusion. Was there anything further, Madam Defense or Mr. Prosecutor?
Nothing for the people, Judge.
No, ma'am. I just need your signature, Madam Defense, on this order of dismissal as the moving party.
Yes, ma'am.
Isn't that odd that we don't have a file of that though?
Yeah. And it was checked off, but I can't find it. Time we checked it off the list.
Mr. Sanders, if you could make sure she signs that.
Yes, ma'am.
Good morning, Mr. Riggins. What do you have here today?
Yeah, I'm here on the D'Angelo Martin matter.
Ready?
Is that his name?
Yes, ma'am. Calling parties on D'Angelo Martin. Calling case number 20-61037, People versus D'Angelo Devon Martin. Defendant is charged with counts 1 and 2, assault with a dangerous weapon, felonious assault. Count 3, malicious destruction of personal property, $200 or more but less than $1,000. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for a motion hearing as well as an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, key 82125, on behalf of Mr. D'Angelo Martin.
Mr. Martin, could you please state your name?
Mr. Martin's not going to be present, and so there are kind of two things going on, and so I will explain. The first of them is this was set for an examination. I did fill out a writ. The writ was signed by this court. I submitted it to MDOC, but at that time I was told that the rules had changed and that the window, or that the time I needed to send a writ had expanded by 4 days, so my writ is no longer considered timely. So I did inform last week, I emailed Tammy as well as Mr. Riggins and let them know we're gonna have to adjourn because there's no way he's gonna be here for this exam. So that's part one. Part two is Mr. Riggins then filed a motion based on a 180-day violation. So that is now an issue. I guess that was filed last week, I think Tuesday. My position, just before we get into it, would be, I would ask for just like an adjournment to say midweek or late week next week, just so I have time to independently verify the facts in the motion, because I think Mr. Riggins' math is right. I just want to make sure I have a chance to verify those facts. And then I will also fill out a Zoom writ so that we can have Mr. Martin present for that motion hearing.
Okay, so you could do that by, today's the 19th, by say the 28th of July. You could effectuate both the Zoom writ and provide your written response to the court?
Sorry, Judge.
Or do you want to say the 30th?
The 30th would be better, it would be safer, but I will get, that should be plenty of time for a Zoom writ, yeah.
Mr. Riggins? July 30th?
Yeah, I can do that, Your Honor. That's fine.
All right, July 30th at 8:30 via Zoom. And Mr. Glimmers, if you could just, if you're forwarding it via email, if you could also bring a hard copy in, since I see you all the time
Yes.
here. That would be helpful to make sure that I've got it and have a chance to review it.
Yes, Judge. And I guess I just want to, do we want 8:30 to be the time for the motion? Because I do have to set like a specific time.
Wait, I'm sorry, say again?
Well, so I do have to set like a specific time for it.
10 a.m.?
10 a.m.? Okay.
Yeah, Mr. Riggins, is 10 a.m. okay on the 30th, or do you want to select the, that's okay? All right.
It's fine, Your Honor.
Okay, again, July 30th at 10 a.m., motion will be heard.
Thank you, Judge.
Mr. Riggins, was there anything further?
Nothing further, Your Honor.
Okay, thanks, sir. Ms. Robinson, are you available?
Yes, Judge, I'm available.
Okay, can you recall that matter? I file or file? I handed it back.
Do you have it up there?
No, I handed it back. I think it's
Jasmine Fly.
fly. I put it underneath another case, so it might be.
Okay. Calling parties on Jasmine Fly. Recalling case number 21-59171, People versus Jasmine Marie Fly. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Remand on behalf of the people.
And good morning, if it may please the court, Sarah Robinson, P63181 for Miss Jasmine Fly.
Okay, and Jasmine Fly, can you state your name?
Jasmine Fly.
Thank you. Ms. Robinson, what's your pleasure today?
Judge, I'm requesting an in-person exam, and also I would like to submit an order for any body-worn camera. I received a paper discovery.
Ms. Yafufi?
Your Honor, I did request the digital discovery. I'm just awaiting a response. And I
Okay.
sent it as of Friday.
All right, given that your client is not in custody, we will assign the first available date, which I think we're in December. Ms. Clark?
December 20th at 10.
December 20th at 10 a.m.?
Yes, Judge, thank you.
Okay, Ms. Fly, that's going to be in person here at the courthouse. Please make sure you mark your calendar and plan to be here in person, not on video, in person. And if there is a no contact provision on your bond, please make sure that you're abiding by that provision while this matter is pending, okay?
Okay.
Anything further, Ms. Robinson or Ms. Yafufi?
No, Your Honor.
No, thank you. Thank you, Judge, no.
Thank you.
Have a good day. Ms. Fly, you can lead the meeting. Thank you.
Okay, thank you.
Calling parties on Davius Weathers. Calling case number 20-61086, People versus Davius Weathers. Defendant is charged with count 1, weapons, firearms, discharged from a vehicle. Count 2, weapons from a firearm. Count 3, weapons, firearms, reckless use. Count 4, domestic violence. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. David Cripps, P34972, appearing on behalf of Mr. Weathers, who's standing right in front of me.
Good morning to you, Mr. Cripps. Could you state your name, sir?
Davies Weathers.
Thank you. Good morning to you. All right, today is the date and time set for a preliminary examination. Are we proceeding to an exam?
Your Honor, the people are ready to proceed, but I believe that defense is seeking to waive the exam.
That's correct. With Mr. Bloomer's permission, Your Honor, and yours.
Is there any objection?
No objection.
Okay, Mr. Weathers, do you understand the allegations against you, sir?
Yes.
Do you understand that you do have a right to a preliminary examination?
Yes.
Do you understand that if an examination did occur, that Mr. Prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
Yes.
And if he were able to meet that burden, the matter would then be bound over. Do you understand that process?
Yes, ma'am.
So the representation made here by your attorney is that you wish to waive, to give up your right to a preliminary examination. Is that true?
Yes.
And do you understand that that would mean that the matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination?
Yes, ma'am.
And is that still what you wish to do?
Yes, ma'am.
Are you doing so voluntarily?
One more time?
Are you doing so voluntarily
Yes.
without any threat or coercion?
Yes.
Thank you. That being said, I do find your waiver to be knowingly and voluntarily given. I will bind this matter over to the circuit court for further proceedings with an AOI date of August 9th. I just need, I'm gonna hand over to Mr. Clerk the waiver form. And I will need your signature, Mr. Weathers, as well as Mr. Cripps's signature,
Yes, ma'am.
and then we'll be all set. Was there anything else that you wish to address?
With the court's permission, I didn't get a chance to talk to Mr. Bloomer about this. But my clients asked me whether you would consider removing the tether condition. The 10,000, 10% bond. It was arraigned on the warrant, it seems like an eternity ago, back on October 9th, 2020. And it's my understanding there's been absolutely no contact, no violations. So my client has asked me, because of his good behavior while on tether, whether the court would consider deleting the tether condition.
It would be highly unusual for me to remove the tether requirement, even with the waiver of the examination. It's just, it's a requirement that's put in place, particularly on domestic violence cases. There's a heightened sense of concern regarding any potential contact. And so for me to remove it would be unusual. I will, however, remove it if the prosecutor is acquiescing to it.
Well, I guess I would just ask for, I am willing to speak with my complaining witness and get their input on the matter.
Oh, is your complaining witness here?
She is, but I can just have a moment ago.
All right, sure.
Thank you.
Can you hand that form to him so he can sign that?
Yes, ma'am.
Thank you.
I'll be waiving Mr. Miller's because he's a commissioner.
Okay, so as we finish with this matter, I'll probably.
Mr. Clements? Oh, wait, hold on, I'm sorry. Mr. Blowers, were you able to speak with your witness?
Yes, Judge. And she did say there have not been any violations at this point, but she is still very concerned about contact.
Yeah, I'm gonna keep the tether in place. As I indicated, it's kind of a standard, unless there's some reason that the prosecution is acquiescing to it, which happens occasionally. It's a safeguard that's put into place to ensure the safety of the complaining witness. And again, it would have been unusual for me to remove it, but I always am open to whatever the pleasure is of the prosecution and the complaining witness. Now that this matter has been bound over, the witness showed up. So I'm gonna keep it, given the representations, I'm gonna keep it in place. However, Mr. Weathers, you have an arraignment on August 9th, and your attorney, an excellent attorney, very convincing attorney, may certainly present that argument again when you face the circuit judge and see what happens at that point, okay?
Okay. Thank you, Judge.
I just need the signature. Oh, I have the signature.
We signed it.
Thank you so much.
Thank you.
Mr. Clements, did you need something, sir?
No, I was just confirming that you guys received everything.
Oh,
I got it. I have it. I just received it.
Okay,
thank
sweet.
you.
Have a good day.
You too. We're gonna forward it right back.
Thank you.
Calling parties on Ryan Minner. Calling case number 21-59211, People versus Ryan Demetrius Minner. Defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, carrying a concealed weapon. Count 3, weapons, felony firearm. Count 4, controlled substance, possession of cocaine, heroin, or another narcotic less than 25 grams. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for a probable cause conference.
Thank you, sir. Appearances, please.
Good morning, Your Honor. Remax Lupe on behalf of the people.
Good morning.
Hey, good morning, Judge David Cripps, P 34972, appearing on behalf of my client, Ryan Demetrius Minner. Judge, I would waive his appearance. He was taken to the Michigan Department of Corrections due to parole.
Oh, I'm sorry. He's in custody?
He's in custody.
Oh.
Unfortunately, they removed him from the Wayne County Jail to the Michigan Department of Corrections.
Okay, so are you requesting to waive his presence for purposes of this PCC?
With your permission, I
Yes, sir. What is your pleasure here today, Mr. Cripps?
we're asking for an in-court preliminary examination.
All right.
It may take a while to get there.
Well, and so he's in custody. Do you know a general time, how much time would you need to effectuate a writ?
I can
Given
do
what
it right
Mr.
now.
Bloomers just said on the record about there was some
Oh, I didn't know anything about
extent, he
that.
had submitted a writ and there was an expiration, there's an additional time frame.
I
Mr.
can-
Bloomers here, I'd hate for us to set a date and then he just indicated something that caused an issue today with one of his exams.
I don't know anything about that, but I can submit one today.
Okay, so, but we still need to know the time frame. Mr. Cripps, do you have an idea of, no?
No, Judge, I wish I did. So different with every facility.
Yeah. Mr. Bloomers, you had just indicated something about MDOC and writs. What was that?
Well, it's just that it used to be 10 days for a writ, and then they said that's 10 days for everywhere except 36, which is 14 days. And that apparently changed at some point between the last writ that I did and this most recent one.
Okay.
So that's the info.
That's helpful. So we're looking at the week of August 2nd or the week of August 9th. If you could let us know what is available. What is he in MDOC on, a parole violation?
Parole hold, Judge.
Okay. So maybe more realistically, we might be looking at August 9th, but just in terms of what we have open, which is not much.
My summer's destroyed.
Right. I agree.
Judge, could we go into the week of August 16th?
Yes, sir.
Do you have anything available on the 18th on your docket?
When you said the 18th?
Yes.
We don't, but we'll make it happen because your client is in custody. August 18th,
If that doesn't work, I could also do the morning of the 19th.
can you take a look, Mr. Clerk, and just see if it's complete madness, which is the lesser of two evils, the 18th or the 19th
The 18th or the 19th?
of August?
Okay. Exact.
Yep. How many proposed witnesses?
2 or 3, Your Honor.
The 19th may be a little bit better. 9:30.
The 19th at 9:30, Mr. Cripps?
That's fine, Judge.
Okay. August 19th, in-person examination at 9:30 in the morning. Any discovery concerns you have, Mr. Cripps?
I never have discovery concerns for her. She's great.
Thank you. All right, we are all set then.
Thank you, Judge.
Thank you.
Call the parties on Torian Jackson. Calling case number 21-55289, People versus Torian Lee Jackson. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, aggravated domestic violence. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of people.
Yes, good morning, Your Honor. May it please the court, Delphia Burton appearing on behalf of and with Mr. Jackson. Great.
Okay, and could you state your name, sir?
Torian Lee Jackson.
Thank you. Any preliminary matters, Mr. Bloomers?
Your Honor, at this time, the complaining witness, Aeneas Cooper King, is not present in the courthouse. She was scheduled to be here for a 10 a.m. preliminary exam. Without her present participation, people are unable to go forward at this time.
Thank you. And again, it's 10:23. This is a matter that was set for 10 a.m. And with that information given by the prosecutor, I am going to grant that motion to dismiss. Keep in mind, Mr. Jackson, that the matter is dismissed without prejudice. And what that trailer language means after the word dismissal is that it is possible that the prosecution can reissue in this matter. If you have questions regarding that concept, please make sure you talk to your attorney and she will explain it to you in greater detail. Do you have on a GPS tether that needs to be removed?
Yes, ma'am.
Okay, I'm going to add that language onto the order of dismissal. We will notify the tether unit from our angle, but it's still important for you to walk away with this so that you can present this order so that there's no confusion about whether or not to remove it when you get to the tether unit, okay?
Yes, ma'am.
Madam Defense, was there anything further?
No, Your Honor, thanks so much.
You're welcome. Have a great day.
Okay, you too.
Good morning.
Thanks. I need to sign something too. You said what?
Sign the dismissal form.
Oh, yes, I have.
Okay, this is for Mr.
That was very good.
You can have a seat in the hallway, sir.
Thank you, Your Honor.
You're welcome.
Okay. You gonna make another one? You gonna take one for me and my client? All right. Yeah, I'll make one big. Yeah, make one first. I think I'm gonna do it. Okay. You know, as long as you keep one, you're here. Oh, great, thanks. Thank you. All right. Okay, have a great day, everyone.
You too, take care.
Let's see who we have. Anyone else up?
Yeah, I think we have Price. Wait a minute. Let me see if he checked. Yeah, he's here. Yeah, Price and Upshar, I can get him in.
Okay, I'm ready. Yeah, can you ask me something?
Yes.
Calling case number 20-58806, People versus Tamara Najee Price. Defendant is charged with count 1, operating while intoxicated causing serious injury. Count 2, operating with a high BAC. Third offense notice felony. Count 3, failure to stop at a scene of an accident, at a personal injury accident. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Akif on behalf of the people.
Randall Upshaw on behalf of Ms. Price, P number 43574.
Thank you. Please state your name.
Tamara Price.
Okay, good morning to you. Today being the date and time set for preliminary examination, are there any preliminary matters we need to take up?
Your Honor, at this time, the people are going to ask the court to hold this exam in part. I do have a complaining witness here who is ready to testify, but I do not have any of the officers here at this time.
And why is that?
I have no idea, Your Honor. They were subpoenaed. I have the subpoenas right here. They just haven't made it here yet.
And are they necessary? I would imagine they are, but I have to ask the question.
They are necessary, Your Honor.
Have you attempted to call their supervisor?
I have not.
Okay, so what we're going to do today is the date and time set for an exam. We're going to proceed. Prosecution can, meet their burden, then so be it. In the interim, before we begin, I think it's important that you make a quick call to their supervisor. Somebody needs to get here. And there must be a supervisor. There must be a number. So I need you to step in the hallway if you could. Call that supervisor, let them know this is a situation, and then call your first witness.
Okay, thank you, Your Honor.
And maybe Mr. Bloomers can assist, I don't know.
Did you need the files for that too?
Do you need files?
Oh, no,
you know what, I was just looking at that. Yeah, I guess I'll just. Yeah, can I see the file, please? Thank you.
Okay.
All of our defendants are here.
Okay, thank you.
Is Mr. O'Neill here?
Yes, he just got here.
Okay, good. All right. Okay.
Both parties on, Garmin is here.
Okay.
Sir, which case are you here on?
Robert.
Oh.
Waiver.
Yeah.
August.
August 9th.
She said he was right. Okay. If her defendant is right, make sure.
Judge, with all respect, I'm trying
Wait,
to
I'm
keep
sorry.
with my schedule.
Wait, I'm sorry. Mr. Sanders, can I trouble you to get a party? I think it was Miss McCoy on you?
Yes.
Miss McCoy, and was that Miss Yellow?
Yes, ma'am.
I mean, if you could call Miss McCoy.
After the one second.
Yeah. Because in essence, he is competent, but was considered. Yes, Mr. Upshaw, I'm sorry.
Yes, the only thing I was trying to say is, Mr. Bloom, Mr. Bloom, it don't take two attorneys. I got a trial at 1 o'clock and I got.
You see, I was trying to
And it's, yes,
encourage that.
If she can't make it, I would just ask for a dismissal without prejudice. And when they get them, they can rewrite the whole thing because it's 40 minutes late now.
Officer, I'm sorry, could I trouble you to have Miss Yahupi return, and if she needs to speak to an officer in charge, that Mr. Bloomers perhaps take that? Thank you. Yeah, no, I definitely understand. Well, you know what, Mr. Sanders, when you get her on the phone, can you just ask her one more time what her understanding was?
Okay, I'm gonna leave her a message because it was his voicemail.
Oh, okay.
She's not making
You want to,
Yes, so
I'm
Mr.
gonna
Sanders,
prosecute.
what I'm,
The
now that I'm
female.
getting this closer, I need to understand what the findings of the findings. Now, to stand trial. So I. People,
Randall Upshaw on behalf of Ms. Price.
and your name again, please? Thank you.
Your Honor, at this time, the people found it in the best interest not to proceed at this time. I believe that defense counsel may ask for dismissal, but we will be reissuing by today.
Okay, I need the complaining witnesses stuff in here, if that's your motion.
Okay.
I'm gonna call him.
Okay, you were saying, could you repeat what you just said?
At this time, Your Honor, the people find that it's in the best interest not to proceed today. We will be reissuing this case with all parties involved present.
Okay, and why is it not in the best interest?
Because our troopers cannot make it to the courthouse right now. They did indicate that they had some sort of training going on. And at this time, the people just find that it's best to have all the testimony put in on the same day.
Is there a motion? Well, no, I'm sorry. That is a prosecutorial motion. So if that's what you're saying, then I'm gonna ask you to sign the order of dismissal, not for Mr. Upshaw to make the motion.
That's fine, Your Honor.
Okay, so with that being said, I'm assuming you have no objection to that motion?
No, Your Honor.
Okay. It is, the reason why I question what the reason for the dismissal was is because it is troubling to have so many cases that come up for examination and the officers, troopers in this case, fail to appear. Regardless of training, regardless of whatever is going on, this is a situation where the offense is serious. And not only is it an operating operating while intoxicated, allegation causing injury to an individual that's present in the courtroom. But this is also an allegation of Miss Price's third offense. So when troopers elect not to show or elect not to give any heads up, this matter was set for an examination in January, 7 months ago. And the officers say, I've got training. I'm not showing. That's unbelievable. Are you Mr. Saad?
Yeah.
As Mr. Saad stands here, thank you for coming.
Of course.
Present and ready to testify. And a necessary officer witness just isn't here. No notification that they would have training or any conflict. They should have been made aware of this 7 months ago. Someone owes Mr. Saad an apology. So hopefully you'll have an opportunity to speak with the supervisor for Trooper Craig and then the other officers that were notified to be here. And they can get on the same page. I'm gonna grant your motion, Madam Prosecutor, to dismiss the case because after all, it's your motion, it's your case. You should understand, Ms. Price, that this is a dismissal without prejudice, and that trailer language after all the bells and whistles of the word dismissal is without prejudice, which means that the prosecutor can go back to her office and reissue this as early as today. This is an allegation of your third drunk driving. I'm assuming just your third. So I'm going to grant the motion. Again, it's your case. Do you have on some form of alcohol monitoring that needs to be removed?
No, I, go, when they call my color, I go, I've been going since, September. They call my color, I go on blow and drop.
I can't hear you, ma'am. Could you speak up?
I'm sorry, since September, I've been going to blow and drop when they call my color. It's like a jams, it's called jams, it's a system.
Yes, yes. So I'm going to add the language on this order of dismissal that that the alcohol monitoring is going to stop because the case has been dismissed. If you would like a separate order form reflecting that, Mr. Clerk can hand you a blank order form and you can prepare that. But I am going to add the language onto the order of dismissal, and I think that should suffice.
Yes, Your Honor.
And in the event that the prosecution does decide to reissue in this matter, I would assume there would be some sort of a heads up so that you can respond accordingly. Okay?
Yes, ma'am.
All right. I just need your signature, Madam Prosecutor, on this motion.
I think I'm going to start starting exam.
Okay.
Everyone have a good day.
You too, Mr. Upshaw. Always a pleasure to see you.
And it's a lot of fight, Your Honor. I'll give it.
Okay.
Officer Williams?
All right.
Well,
Mysick, P74620, on behalf of the people.
Good morning, Christine Longstreet from Neighborhood Defender Service, appearing on behalf of Mr. Ricky O'Neill.
Please state your name. Please state your name.
Ricky O'Neill.
Okay. Are there any preliminary matters before we proceed to an examination?
Your Honor, I would only ask for an order of mutual sequestration of witnesses with an exception for my officer in charge, Detective Anthony Bessa.
Any objection to the officer in charge remaining?
No, Your Honor.
Okay.
Now, I would just bring to the court's attention that Detective Bessa is currently not in the courtroom. He's checking in front of Judge Jefferson, and so he should be back momentarily.
Okay. Sequestration is granted with the exception for the officer in charge. The Zoom gallery has been reduced to only those that are working here in the courtroom. I'm going to enable the waiting room. If you hear anyone chime in, it will be because I've let them in. Typically, that's because they're an attorney. The third tier, well, the first tier of sequestration is the courtroom, which is already restricted due to COVID restrictions that are in place. So there are no spectators in the courtroom. The next level of sequestration would again be the Zoom gallery, which I've just addressed. And the third tier of sequestration would be the live proceedings on YouTube. So if there's anyone watching the live proceedings that should not be watching it because you're either a witness in this matter or a potential witness, now would be the time to stop from watching the live proceedings to maintain the integrity of this process as it may preclude you from testifying in the future. Anything further?
Just to let the record reflect that Detective Bessa is attorney. Other than that, nothing further from the people. We're ready to proceed.
Okay, first witness.
People calls our first witness EMT Daniel Owens.
Okay, good morning to you. Could you please come a little closer to the podium so the microphone can illuminate, allow your voice to resonate clearer? Can you state your full name and spell your first and last name for Madam Court Reporter?
Daniel Owens, DANIEL OWENS.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Come around this way. That little half gate will open up towards you. Have a seat. Mr. Mysick, your witness once he's settled.
Thank you, Madam. Morning, sir.
Good morning.
And Mr. Owens, how are you employed, sir?
I'm employed with Detroit Fire Department, EMS Division.
And do you carry a rank with that employment?
Yes, sir.
What is that rank?
EMT Basic.
EMT Basic. So would it be appropriate to call you EMT Owens?
Yes, sir.
All right. And how long have you been so employed as an EMT? What does EMT stand for?
Emergency Medical Technician.
And how long have you been an emergency medical technician?
Since 2019, sir.
And how long?
2018, sir.
And how long have you been with the fire department?
3 years, sir.
Now, were you a paramedic with the Detroit Fire Department on July the 6th, 2019?
I was an EMT Basic at the Detroit Fire Department, sir.
I see. And on that date of July the 6th, 2019, were you on duty?
Yes, sir.
All right. And on that date, were you working alone or with someone?
I had a partner, sir.
And what's your partner's name?
Brendan Riggs, sir.
And on July the 6th, 2019, what was your unit call sign?
Medic 13, sir.
All right. And on July the 6th of 2019, did your duties take you to Harper and Harrell Streets?
Yes, sir.
Okay. And those streets, do they intersect?
Yes, sir.
And does that intersection occur in the city of Detroit?
Yes, sir.
County of Wayne?
Yes, sir.
State of Michigan?
Yes, sir.
All right. And why did your duties take you to that intersection? What took you there?
We were called Code 1 to a motor vehicle collision, sir.
What does Code 1 mean?
Code 1 means licensed sirens high priority.
And so it's fair to say that you were dispatched to that intersection?
Yes, sir.
Okay. And what time of the day or night were you dispatched?
Approximately 22:30, sir.
That's 22?
22:30, sir.
That's 22:30 on the 24-hour clock?
Yes, sir.
What time would that be in normal time?
10:30 p.m., sir.
And did you make the intersection of Harper and Harrell Streets?
Yes, sir.
Okay. And when you arrived there, what were the lighting conditions like, if you remember?
Dark, sir.
And what was the weather like, if you remember?
Clear, sir.
Any precipitation at all?
No, sir.
And when you arrived, were there any other emergency personnel on the scene?
No, sir.
Okay. So when you got there, what, if anything, did you observe?
I noticed one vehicle with 2 occupants inside, and the vehicle had struck a tree.
And do you recall what type of vehicle it was?
A white SUV of some form, sir.
Your Honor, may I approach the witness?
Yes.
EMT Owens, I'm approaching with what has been marked as People's Proposed Exhibit Number 1. Do you recognize what is depicted in People's Proposed Exhibit 1?
Yes, sir.
And how is it that you recognize that?
I was there that night, sir.
Okay, does that fairly and accurately depict what you saw
Yes, sir.
at the scene
Yes, sir.
when you arrived?
Yes, sir.
All right, people move for the admission of People's Proposed 1.
Any objection? No, Your Honor. Thank you. It will be admitted as People's 1.
And EMT Owens, what is depicted in People's 1?
A vehicle that had struck a tree, sir.
All right.
Pardon?
A vehicle that had struck a tree, sir.
And is that the vehicle that you saw when you arrived at the scene?
Yes, sir.
All right. Your Honor, permission to publish? Yes. Would you hand that to the court?
Thank you.
Thank you, sir. Now, you said just a few minutes ago there were 2 occupants in the vehicle. Is that correct?
Yes, sir.
Okay. And do you recall where those occupants were seated?
Both in the front seats, sir.
Okay, so one behind the driver's wheel, one in the front passenger seat?
Yes.
Okay. Talk about the person in the front passenger's seat first. Do you recall what gender they were?
Yes, sir.
What gender were they?
Female.
Okay. And did you notice anything about this person's condition?
That she had no pulse and she was not breathing.
Did you do anything to treat this person?
I did not, sir.
Okay. Did you observe your partner, paramedic Riggs, doing anything to treat this person?
Yes, sir. He was the one that made contact with that patient, and he is the one who noted that there was no pulse and that was not breathing.
I see, thank you.
Yes, sir.
And so did you go to the person behind the driver's wheel?
Yes, sir.
Okay. And what, if anything, did you note about this person?
I noted that he was unresponsive, and that there was a large amount of trauma to the face.
Can you describe what you mean by a large amount of trauma?
Swelling
Any blood?
Not that I can recall offhand, sir.
And do you recall anything regarding this person's gender?
He was male, sir.
And how about their ethnicity?
African American.
Did you observe anything about the person's age?
Approximately 40 to 45.
Okay. And did you treat this African American gentleman?
Yes, sir.
Okay, how did you do that?
We removed the gentleman from the vehicle. We placed the gentleman on the cot. We attempted to secure an airway, treat vital signs, apply oxygen, and transport code 1 to the hospital, sir.
How did we do that last part?
We took the gentleman out of the vehicle. We placed him onto the cot, secured him in the ambulance, attempted to establish an airway, applied ventilations, gave oxygen, and transported code 1 to the hospital.
And when you say code 1, again, that was lights and sirens?
Lights and sirens, high priority, yes, sir.
Okay. Now, who drove the rig?
My partner did, sir.
Okay, and so what were you doing while he was driving?
I was in the back of the patient.
All right. And while you were treating the patient, may sound silly, but did you treat this person with any amphetamines?
No, sir.
Any benzodiazepines?
No, sir.
Any cannabinoids?
No, sir.
Any alcohol?
No, sir.
Okay. And did you, was this person transported to a hospital?
Yes, sir.
Which hospital, if you recall?
St. John's, sir.
This happened in 2019, correct?
Yes, sir.
Do you recall what the driver looked like?
The driver was, of that vehicle was a African-American male.
Right.
Approximately 40 to 45 years old.
Okay. And if you saw that person again, would you recognize them?
I would not, sir.
All right, thank you. No further questions, Your Honor.
Cross-examination.
Good morning.
Good morning.
How long do you think it took you to arrive on scene, once you received the call?
I do not recall. I would have to refer to my report.
Judge Mayor, I approach.
Yes.
You want me to move over? Oh. Okay.
Thank you.
Okay. Is that your report?
Yes, ma'am.
Take a look at it and let us know when your memory is refreshed.
Could you repeat this?
I said, take a look at it and let us know when your memory is refreshed.
4 minutes.
Okay. And so, and you're the first person to arrive on the scene, correct?
Yes, sir.
First person. At
Or
some
ma'am,
point.
excuse me, ma'am.
Pardon me?
Yes, ma'am.
Okay. At some point, do other emergency vehicles or police or fire arrive?
I do not recall.
And you said it was dark outside?
Yes, ma'am.
Okay, is this a residential area?
No.
No.
No, ma'am.
Okay, so it's a commercial area?
Harper on that side of the street would be, yes. It borders neighborhood that is north of that area.
Okay, and you said that it was clear outside, meaning there was no rain?
Yes, ma'am.
And when you arrived, did you immediately go to the driver?
I did, yes, ma'am.
Okay, and that person couldn't speak, correct?
Yes, ma'am.
And so you weren't able to ascertain how the accident occurred, is that fair to say?
Could you repeat, please?
You never had a conversation with them, is that fair to say?
Yes, ma'am.
And would you say that, strike that. You began to treat him immediately. How long between the time that you arrived and you depart with that driver? Are you referring to something?
Yes, ma'am. I have to refer to my report for that.
Would that refresh your recollection, sir? Excuse me.
Yes,
Would
ma'am.
that refresh your recollection?
Of how long we were with the patient?
Yes?
Yes, ma'am.
Okay, so before you just look at the report, please let us know.
Okay, my
in
apologies.
advance,
I did not know.
And then review the report and then place the report face down, and defense will pick up.
Yes, ma'am, my apologies. I would like to refer to my report for that answer, please.
Yeah.
Thank you. 5 minutes, ma'am.
Okay, so very quickly, right? What you
Yes,
said?
ma'am.
Do you know who placed the call?
No, ma'am.
All right, I have no further questions.
Can you redirect?
No redirect, Your Honor.
Okay, thank you, sir. You may exit the courtroom.
Thank you.
Make sure you.
Your next witness?
People call Detective Anthony Besso.
Sir, could you please state your full name and spell your first and last name for Madden Court Reporter?
My first name is Anthony, which is Anthony. Last name is Besso, Besso.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. Please have a seat up here in the witness chair. Your witness, and the prosecutor.
Thank you, Your Honor. Morning, Detective.
Good morning.
Detective, you're a detective with the Detroit Police Department, correct?
That's correct.
And what is your current duty assignment?
I currently work at Fatal Squad.
Okay, and was that your duty assignment back on July 6th, 2019?
Yes, it was.
Okay, and what does Fatal Squad do?
Fatal Squad handles all of the critical and fatal car crashes for the whole city.
Okay, and were you on duty on July the 6th, 2019?
Yes.
And did your duties take you to the intersection of Harper and Harold Streets?
Yes.
In your experience, is it Harrell or Harold Street?
I think it's, well, actually, I'm not even really sure.
Okay. But you went to the intersection of Harper and Harold Street?
Yes.
And that's in the city of Detroit?
Yes, it is.
County of Wayne, state of Michigan?
Yes.
Okay. Now, was this the first crash you've ever been dispatched to?
No.
Okay. Well, how many crash scenes have you responded to as a police officer?
Oh, geez. Probably 700 or plus.
How about as a member of Fatal Squad?
Probably more than 500.
And in order, to be in Fatal Squad, do you have to have any special training?
Yes.
What kind of training must you have?
They want you to have at least AI 1 and 2, which is accident, investigation, 1 and 2.
And
at a minimum.
And at a minimum, and do you, have you taken those classes?
Yes.
Have you taken those classes?
Yes.
Okay, and what is involved in being an AI1 or AI2?
For AI 1 is just your basic field sketch, scene measurements, some basic speed formulas are in there. For AI 2 is taking field sketches, drawing them to scale, and also some time and distance formulas are in AI 2.
I see. And have you taken these classes?
Yeah.
Who put the classes on?
Michigan State University.
All right. And when you took the classes, can you describe the coursework? Was it hands-on? Was it solely lecture?
It was both.
It was both. All right. And did you have to take any test or anything at the conclusion of those classes?
Yes.
Both of them?
Yes, both.
And did you pass those tests?
Yes.
All right. And as a result of passing those tests, were you certified in any way?
Yes.
What were you certified as?
As a, well, I mean, it's just a certificate, for AI 1 and AI 2.
Okay. And you had that training before you went to the scene at Harrow and Harper Streets?
Yes.
Okay. So when you went to the intersection of Harper and Harold Streets, did you go there alone or with somebody?
I was there with, I think, Sergeant Todd or Sergeant Warner.
Okay. Anybody else?
I can't remember.
Did you write a report on this matter?
Yes,
And would that report indicate who you responded to the scene with?
yes.
Okay, just one moment. Ron, may I approach the witness?
Yes.
Detective, I'm handing you 2 sheets of paper. Do you recognize what I'm handing you?
Yes, this is my investigator's report.
And is that the report that you need to refresh your recollection about who you responded to the scene with?
Yes.
Take a look at it. Use it to refresh your recollection. Look up when you're done. Let me get that out from you. Thank you, sir. And so who did you respond to the scene with?
Sergeant Warner, Sergeant Todd, and Detective Kelly Austin Brown.
Okay. And when you arrived, typically when you come to a crash scene, what's the first thing that you normally do?
Normally I just walk the scene just to see what I have out there.
Okay, and did you do that in this case?
Yeah.
So when you did that in this case, what did you have out there?
So this scene was a single motor vehicle crash involving a white Ford Explorer. It was on the north side of Harper, just east of Harrell.
And the vehicle that you saw, you said it was a white Explorer, was it?
Yes.
Okay, and what kind of vehicle is that? Is it a sedan? Is it a pickup truck? What?
SUV.
Okay. And where was this vehicle? And you said it was on the north side of Harper?
Yes.
And
it was on the north side of Harper facing eastbound, and it had struck a tree basically head on, and the vehicle was still facing eastbound.
And let me ask you this, did you, besides the vehicle, did you typically make any observations about anything that's on the ground?
There was a broken wine bottle or liquor bottle that was in the roadway.
Okay. Was there anything unique about this broken bottle that drew your attention?
Not really.
Okay. Do you know if photographs were taken of that bottle?
Yes, yes, there were.
Your Honor, may I approach the witness?
Yes.
And Detective, I'm approaching with what have been marked with people's proposed exhibits 2 and 3. Do you recognize what's depicted in people's proposed 2 and 3?
Yes.
Okay, and how is it that you recognize that?
This is the broken wine bottle that's in the roadway.
Okay, and does that fairly and accurately depict what you saw in the roadway?
Yes.
The night when you responded to the scene?
Yes, it is.
People move for the admission of people's 2 and 3?
Any objection? No, Your Honor. Will be admitted as people's 2 and 3.
Thank you. Now I want to direct your attention, Detective, to people's 3. And what's specifically what's depicted on people's 3?
This is the label off of the wine bottle.
Okay, and has that label been changed in any way?
It says Carlo Rossi, but it's crossed out Rossi, and then somebody wrote Rick right above Rossi.
I see. Now, did you do that?
No.
Okay, is that how you found it?
Yes.
All right. People move to publish people's 2 and 3?
Okay.
Would you hand those to the judge?
Yes.
Now, your observations of the road wasn't just limited to broken bottles, is that correct?
That's correct.
Okay, now, when you go to a crash scene as a crash investigator, what kind of things are you looking for to give you a clue about the crash?
If there's any type of like skid marks, braking, yaw marks, scrapes, or gouges.
Okay, now what are yaw marks, scrapes and gouges, what are those?
Well, for a skid mark, it would just be either braking or somebody, accelerating. As far as a yaw mark, that would be a vehicle losing control without braking, but the wheels are still spinning. Scrapes and gouges are just deep cuts like in the pavement from metal.
I see. And so, how are these marks made? Like how do you, like, if you saw them at a scene, are they, and you said that with the gouge marks, you said that they're made by metal, correct? And let me ask you this, how is it that these other marks are placed onto the road? Like what, as I said, that the gouge marks.
Well, braking, during rapid braking, the tire will heat up and actually leave, rubber on the road.
I see, so that's what you're looking for?
Yeah.
Okay. And did you observe any of those things at this scene?
There was no skid marks at this scene.
Did you find any evidence of braking?
No.
Now, did you have the opportunity to examine that SUV when you were at the scene?
Yes.
And what, if anything, did you observe when you examined it?
It had front end damage where it was resting up against the tree. And it also had a liquor bottle in the driver's side floorboard. And the female was still in the front passenger seat when I was there.
Okay. Did you smell anything inside the vehicle when you were there? When you saw it, when you were examining it?
It smelled like liquor on the inside of the vehicle.
I may approach the witness?
Yes.
Detective, I'm approaching you with what have been marked as people's proposed 4, 5, and 6. Please take a look at them. Tell me if you recognize what they are.
Yes, I do.
How is it that you recognize those?
This is the bottle of vodka that was on the driver's side floorboard.
All right. And do those pictures fairly accurately?
I can't hear you.
I'm sorry. Do those photos fairly accurately depict how you saw the bottle?
Yes.
When you examined the vehicle on July the 6th, 2019?
Yes.
People move to the admissions of people's proposed 4, 5, and 6?
Any objection? No objection. People proposed 4, 5, and 6 will be admitted as 4, 5, and 6.
All right. Now, those photographs, is that like a progression of photographs?
Yes, exhibit 4 is a little further zoomed out, 5 is closer, 6 is closer.
And does people's 6, does that indicate what type or what brand of alcohol it is?
New Amsterdam grapefruit vodka.
Right. People move to publish 4, 5, and 6?
So, Ms. Yafubi? Ms. Yafubi? We're getting ready to recall the matter with Ms. McCoy. I just didn't want you to go far. Okay. Okay. Yes.
Yes.
Now, besides your observations at the scene and the SUV, did you take any measurements of the scene or, did you take any scene measurements?
Yes.
Okay. And why do you take measurements at a crash scene like this?
Just to mark and record the evidence. If, this case we have to come back and revisit the scene at a later date. At least we know where everything was at.
Okay. And how do you go about taking those measurements?
By using tapes.
Tapes, just like measuring tape?
Yes. Yeah.
Okay. And did you do that in this case?
Yes.
And let me ask you this. Once, in addition to making those measurements, did you do what's called a scene sketch?
Yes.
And why do you do a scene sketch?
Just to record and mark the evidence.
All right, may I approach the witness?
Yes.
Detective, I'm approaching what is marked as People's Proposed 7. Do you recognize what that is?
Yes, this is my field sketch.
Right, and is that the sketch that you created, a copy of the sketch that you created in this case?
Yes, it is.
People move for the admission of People's Proposed 7.
Any objection?
No objection.
People's proposed 7 will be admitted as People's 7.
Right. Now, could you hold up People's 7 so the court can see and just describe what's depicted there?
So the sketch is showing Harper, which runs east and west, and shows Harrell, which runs north off of there. And then I also drew the white Ford Explorer just east of Harrell on the north side of Harper, facing eastbound.
Now, you'd agree with me that there's a box located at the right hand of what looks like a street. Is that correct?
Which box are you talking about?
And it's a box with a triangle.
Yes.
And what does that box signify?
The direction that the vehicle was facing.
Is that why there's a triangle, that triangle there?
Yes.
Okay. Now, and so if that's the way it's facing, correct? And then and just so that I'm clear, the direction of travel for Harper, in which way would the traffic be running?
This would be east and west for Harper.
Okay, so just for the record, I'm pointing to the top lane. That this is Harrell up here, correct, towards the top of the.
Yes, yes it is.
And this is run perpendicular to 2 lanes of Harper, 4 lanes of Harper. How many lanes of Harper is there?
I think there are 4 or 5. It might be 4 with a center turn lane.
Okay, so I'm pointing to the first lane of traffic off of the perpendicular running Harold Street. So which way would traffic be running? Would it be left to right or right to left?
From right to left, which would be westbound.
Okay, so the traffic would be going in this direction, from my right, or I should say from the left of the page to the right of the page?
From the right of the page to the left of the page.
I see. So then the other,
Westbound traffic, yeah.
so then the other lanes towards the bottom of the scene sketch, that traffic would be running from the left of the page to the right, or to the right of the page?
From the left to the right, correct.
Okay. And so then the depiction of the vehicle then, is that in oncoming traffic?
Yes.
All right. Your Honor, I'll move to publish this exhibit to the court.
Yes.
Thank you.
Thank you.
Now, you said that there was a person still in the vehicle when you saw it, correct?
Yes.
Okay, and did you recall if this person was a male or a female?
Black female.
And did you recover that person's a driver's license or other identity card?
I think she had a out-of-state license on her, yes.
Okay. Do you recall what that person's name, was that license recovered?
Say that again?
Was that identification, whatever it was that recovered?
Oh, yes, yes it was.
And do you recall the name on that identification card?
Lynette, the last name I think was Horton, Horton. Horton.
And when you saw the body, was it alive or dead?
Dead.
Right. Your Honor, at this time, I would move for the admission of People's Proposed 8. This is the Wayne County Medical Examiner report number 19-8260. And the report details a postmortem examination on the body of Lynette Horton. And I would move for this document's admission pursuant to MCL 76611B 1D.
Have you had an opportunity to review this report? Madam Defense?
Yes, Your Honor.
It will be admitted as People's Exhibit number 8.
Thank you, Your Honor. And by way of the summary and opinion, the report details that Dr. Jeffrey Hudson, common spelling of both Jeffrey and Hudson, it's Jeffrey, as medical examiner, states that on July the 7th, 2019, that it is my opinion that death was caused by multiple blunt force injuries sustained as a passenger of a vehicle involved in a collision. He further finds that the manner of death is classified as an accident. I can give the court a recitation of the multiple injuries, if you'd like.
No, you can just publish it to the court.
Very well, may I approach, Your Honor?
Yes.
And Detective will ask you to hand that to the court.
Thank you.
Thank you. All right. Now, Detective, the crashed SUV, did you do any investigation into that vehicle?
As in what?
Well, did you find, did you investigate who owned or who the vehicle was titled to?
Oh, yes, yes.
And did you find out who it was titled to?
Yes.
Who was that?
Ricky O'Neill.
And so did you do any investigation of the person known as Ricky O'Neill?
We got the toxicology back from the hospital, from St. John Hospital.
I see. And when you say you got toxicology back from the hospital on Ricky O'Neill, what does that mean?
It means somebody served a subpoena to get the toxicology.
I see. And did you ultimately obtain a report or anything from the hospital?
Yes, I did.
And you recall what hospital that was?
St. John Hospital.
All right. Your Honor, I would move for the admission of People's Proposed Exhibit 9, which is a drug and urine analysis report from Ascension St. John Hospital on patient Ricky Donnell O'Neill.
Any objection? No, Your Honor. It'll be admitted as People's 9.
Thank you. May I approach the witness, Your Honor?
Yes.
I'm going to continue with People's 9. Do you recognize that?
Yes.
Okay. Now, this particular document, does it detail any information about Mr. O'Neill's blood alcohol level?
Yes, it does.
Okay, and what does it indicate?
It indicates a BAC of 0.078, a serum.
Now, because is in your experience, is serum blood alcohol level different than whole blood alcohol level?
Yes, it is.
Okay, and how is it different?
It's actually higher than the whole blood, so it has to be converted by dividing by 1.16.
Okay, so in fact, the BAC in reality is actually lower than what's listed there.
That's correct.
Okay. Now, does the report also give any indication about any other substances that are in, or that were found to be in Mr. O'Neill's urine?
It does have drugs listed on here as well.
Okay, and does it list any positive analyses for any kind of drugs?
Yes, it has positive for benzodiazepines, cannabinoids, and amphetamines.
Does it give any specific amount?
It just says positive, abnormal.
All right. Your Honor, would you like to publish this as well?
Sure.
All right. Yep, thank you. Now, did you also have the occasion to examine Mr. O'Neill's driving record?
Yes, I did.
And did you determine if Mr. O'Neill was eligible to drive at the time of the crash?
He was not.
Does he have a valid license?
Not on the day of the crash, no.
Okay. And Your Honor, I have on my account is people's, excuse my stutter, people's proposed 9.
No,
I'm sorry,
proposed what?
9 or is it 10?
It should be 10, I have 9.
I see. People's proposed 10. The document is, purports to be a certified copy of the driver's record for a Ricky Donnell O'Neill, birth date of 6/25/1961. And the document is electronically certified in compliance with MCL 257.204A. And it's also a self-authenticating record under MRA 902, subsection 2, 4, and 10. And for what it's worth, it's also admissible under 76611B, 1, subparts B, C, D.
Have you had an opportunity to review this, Madam Defense? Yes, Your Honor. Thank you. It will be admitted as People's 10.
And may I approach the witness stand?
Yes.
You recognize People's 10?
Yes, it is.
Okay, and is that the document that you used to determine the defendant's eligibility to drive in July 2019?
Yes.
People move to publish People's 10.
Thank you.
Now, finally, you agree with me that the defendant in this case is named Ricky Donnell O'Neill, correct?
Yes.
And was this defendant taken into custody by the Detroit Police Department?
Yes.
And did you learn this defendant's birthday?
His what?
His birthday?
Oh, yes.
And do you know defendant's birthday?
Not off the top of my head, I have to see the driving record again. Or if you have another document.
Oh, yeah. Did you report it somewhere?
It's probably in my report here.
May I approach the witness, Your Honor?
Sure.
Again, I'm approaching you with 2 pages. Do you recognize that?
Yes, this is my report. The date of birth, 6/25 of 1961.
I'll recover those from you. Thank you, Detective. And you know the speed limit on Harper at this intersection?
The speed limit on Harper is 30 miles per hour.
Thank you. No further questions.
Okay, before we begin with cross-examination, could I trouble you to get Ms. Yakufi from the hallway, Mr. Bloomers? Or Mr. Misick?
I got it.
Thank you. Hello, this is a recall of People versus Robert Ewell, 2005653. This case was already formally called. Can I have appearances, please?
Yes, good morning, Your Honor. Rima Yakufi on behalf of the people.
And good morning, Your Honor. Robin McCoy on behalf of Mr. Robert Ewell, P63057.
Thank you. The reason why I'm recalling this is because I just want to make sure that I'm crossing my T's and dotting my I's appropriately. Counsel, you indicated that you were stipulating to the findings of the report, as did the prosecution, correct?
That's correct, Your Honor.
So the finding was that the defendant is competent to stand trial. Is that your understanding of what you're stipulating to?
Your Honor, it was competency and criminal responsibility. So he was competent to stand trial, but for criminal responsibility, that he was deemed legally insane for both the arson and the firebombing, the alleged firebombing case.
Okay, and my concern here at this level is the competency to stand trial. So I just want to make sure that the documentation is going to coincide with what I heard both the prosecution and the defense say they're stipulating to. And that would be consistent with the report that indicates the bottom line, that he is competent to stand trial. Is that what you're stipulating to? And I understand the further verbiage regarding criminal responsibilities, but my file needs to make a finding. And typically my finding is consistent with the report when there's a stipulation.
Yes, Your Honor, we'll so stipulate that he's competent to stand trial.
Okay, so thank you. It was just that minor detail that I wanted to make sure that we're all on the same page. I do understand your what you were indicating about the criminal responsibility, but what you will get a copy of is my finding in accordance with the stipulation, which is that the defendant is competent to stand trial. So I just didn't want anyone to be thrown off if and when you receive that and it hasn't been fully fleshed out here on the record. So I think we're all set here. I just, as a matter of course, wanted, when I talked to Mr. Clerk about it, the paperwork, I just wanted to make sure that it was reflecting the fullness of what we talked about. Okay?
Okay, all right. Thank you, Your Honor.
Is there anything further?
Nothing further, Your Honor.
Okay, thank you.
See y'all later. Thank you.
You too. All right, we're back on the record. Can I have Ms. Longstreet, can you pick up with cross-examination? Mr. Clerk, I don't know what I did with that form. Can you print out the label? The form that I was looking at.
The findings.
Yeah.
Okay.
Your witness.
Detective Buffalo, how long were you at the scene?
I can't hear you, sorry.
I'm sorry, how long were you at the scene?
Oh, probably about an hour.
Is this a residential or commercial area?
It borders the 94 service drive, so there is homes on the north side of Harper, but the south side would be the freeway.
Okay, did you go to any of those homes to see if they had video or ring doorbell?
No,
Okay, did you follow up to, talk to the person who called in the 911?
I can't remember.
You can't remember if you did or if you,
I can't remember if I did.
okay. Certainly, if you had talked to someone who had possibly seen the accident, that would be reflected in some report. That would have been documented somewhere, right?
Yes, yes.
And do you still have your report?
Not back here.
And just so I'm clear, I'm referring to your report, and the prosecutor handed me what amounts to 2 pages. Is that fair to say? Is this in fact your report?
I think it's, yes.
Okay, so your report actually is a summary of what happened that day and individuals who are potential witnesses. Is that fair to say?
Yes.
Okay, and those individuals are all police or fire related, correct?
Yes.
And so there's no mention in your report of following up with the person who would have called 911.
Not on here, no.
Okay, and would you, well, you said not on here.
No.
That's the only report you have, right?
Yes, yes, that's,
And would you agree that it was dark outside?
yes.
Okay, and strike that. Do you know what time you were arrived on scene in relation to the EMS?
It would have been after medics.
Okay, so is it fair to say that when you arrived on scene, the medics are gone?
That's correct. Yes.
Okay, and so there's no one there except for the deceased that's in the passenger seat?
That's correct.
Okay, and is it also fair to say that that individual had cocaine or alcohol in their system?
Objection, Your Honor, well, the victim is, well, I can elaborate for which is.
I can respond, the prosecutor introduced evidence of liquor bottles near the scene and in the vehicle, so I think it's relevant.
Objection overruled.
I don't have the toxicology for the front seat passenger.
Did you look at the, coroner's report, the MU's report?
Not for her, no.
Okay. And when you arrived on scene, the deceased, that individual is still in the car, is that fair to say?
Yes.
Okay, and so the first thing you do when you arrive on the scene is what?
First thing I did was walk the scene, to see what was out there, and then I did the field sketch and scene measurements.
Okay, were there any other police or EMS present on the scene that have been moving about the area?
Medics were gone when I got there, but there was other Detroit police officers on scene.
Okay, and do you know what they were doing?
Blocking traffic.
Okay, so they were blocking traffic. And did you take only those photos that have been admitted into evidence, or did you take more photos of the scene?
Those photos were taken by our evidence tech unit, as far as I know.
Oh, okay, so you didn't take any photos?
No.
Okay. You just reviewed the evidence tech photos?
Correct.
Okay. Did you instruct them to take photos?
Yes.
Okay. Did you instruct them to take photos of the pavement?
Yes.
And the driver of the vehicle wasn't on scene when you arrived, correct?
That's correct.
Okay. Now you mentioned, the prosecutor asked you if you saw any skid marks,
Yes,
and you said no.
that's correct.
And skid marks at a crime scene could mean that someone broke or they tried to avoid something.
Yes.
Okay. In every crime scene, when someone breaks or tries to avoid striking someone or something, are there skid marks?
Not in every case, no.
Okay. And the same would go true for what you call yellow marks and scrapes, correct?
Correct.
Did you did this vehicle have a black box?
I don't believe it did, no.
Okay, you don't believe or didn't?
I'd have to look at my report to see.
If it'll help.
Okay. The vehicle was not supported for adopter.
So when you say not supported, that means that no black box exists?
That's correct, yeah.
Did you ever review any of the driver's medical records, or the person that you believe was driving? Did you review any of medical records?
No.
So were you able to determine if this crash would have or could have been the result of a medical emergency?
That I don't know.
As it relates to the blood alcohol in the toxicology report, do you know when that blood was drawn?
There should be a date and a timestamp on that.
Do you know when the cocaine or marijuana was ingested?
I'd have to see the report from the hospital again to get the time on that.
No, I'm not talking about when it was done. You can't look at the report and tell when those items were ingested, right?
Oh, no.
Okay, and you can't look at the report and tell whether or not someone was under the influence of those items at the time this accident occurred. Is that fair to say?
That's fair to say.
And also, I note in your report that you said that the airbag did not deploy.
Yes.
And is that something that you typically see in a crash with this level impact?
It does happen, yeah.
Okay. When you say the airbags didn't deploy, do you mean both airbags?
I can't remember. I'd have to see the photos of the inside of the car again.
Does that mean that there was something defective with the airbags or the vehicle?
I'm not sure.
Well, okay, so you're an accident reconstruction,
Yes.
right? And with this level of force, you would expect the airbag to deploy, right?
They should have, yeah.
Okay, and if you note that one or more didn't, it would be because there's some sorts of defect with the vehicle, at least as it relates to those airbags. Is that
It's a
fair to say?
possibility, yes.
But let me just walk over to my client. So I have no further questions.
Thank you.
Thank you.
Any redirect?
No redirect, Your Honor.
Thank you. You may exit the witness stand.
Thank you.
I don't see his weapon. Any further witnesses for the prosecution?
No further witnesses, Your Honor.
Is there a motion? I'm sorry, Ms. Longstreet, did you have any witnesses?
I don't have any.
Is there a motion?
Yes, Your Honor, we can make a motion to bind over on the 2 charges of reckless driving causing death, operating a license suspended or revoked, denied causing death.
Okay, I'm sorry, could you say that again?
Yes, motion comes to place, Your Honor. People move, Your Honor, to bind over the defendant on the 2 charges alleged reckless driving causing death and driving license suspended, revoked, denied causing death.
Thank you. Is there a response from the defense?
Judge, I would, first of all, I would say that I don't think the police people have established that my client was driving the vehicle, established this is the vehicle. No one's come forward to identify him or say that we took ID off the individual who was in the driver's seat, who was taken to the hospital. You don't have any of that. What you have is someone saying, hey, this is the toxicology report, and this is the person who was arrested. Moreover, as it relates to the reckless driving causing death, Your Honor, I would say or suggest to the court that even to the people's witness, he doesn't really seem to know how the accident occurred. He says that he arrives, there's a car that struck a tree, there's a passenger who's deceased, and really, there's nothing more. Nothing more. Judge, I don't think that people have met their burdens, even to probable cause. Thank you.
Judge, as this court knows, that the court can bind over on direct evidence and reasonable inference drawn therefrom. People have shown that the driver of the vehicle was an African-American gentleman of approximately middle age. The witness that EMT Owens indicated that he was between 40 and 45. The defendant's age in the 50s is a little bit older than his range. However, EMT Owens did indicate that the driver of the vehicle did have facial injuries. The face was swollen, and so his perception of age obviously could very well be a little off, but it's still within the ballpark. Judge, defense counsel is correct. We have shown that the defendant did own the vehicle involved in the crash, and the focus of the police investigation was regarding the owner of that vehicle who matched the description. And so ultimately, Your Honor, as I think that the people have shown to the probable cause standard, certainly circumstantially, that the defendant was the driver of the vehicle, thus satisfying the first element of both reckless driving causing death and driving with license suspended or revoked causing death. The people have shown, Your Honor, that this is a public street, that arguably the defendant was operating the vehicle on that street. We've shown that the defendant's operator's license was suspended or revoked from the defendant's driving record. And so ultimately, I think that also, Your Honor, we've shown that the defendant drove the motor vehicle in willful or wanton disregard for the safety of persons and property. In this case, Your Honor, we have a situation where a vehicle, from the scene evidence, and when you look at the scene sketch, it appears that the vehicle traveled left of the center lane, crossed into oncoming traffic, and struck a tree. Typically, Your Honor, that is not safe operation of a vehicle. Moreover, as defense counsel pointed out, if there was a, well, let's strike that. But ultimately, Judge, we have a situation where this vehicle, as I said, crossed into oncoming traffic and struck a tree. More importantly, to note is what Detective Bessel didn't find at the scene. That was evidence of braking. So it does not appear that the defendant, while driving the vehicle, took any preventative or any evasive action to keep from striking the tree. And so that is not just simple carelessness, but this is a knowing disregard for the possible risk to the safety of himself, the people who are around him. Because as defense counsel pointed out here, that this was an area that was partially residential. And so clearly the defendant should not have been driving in the way that he did, such that he would not brake to miss striking a stationary object. So again, the people have shown that the defendant drove the motor vehicle in willful or wanton disregard for the safety of others. Now, regarding the elements of causation, Your Honor, both are alike for both of the charges alleged, that the people have shown that the defense operation of the vehicle was the factual cause of the death, that but for the vehicle striking the tree, the multiple injuries detailed in the medical examiner report would not have occurred, thus resulting in the victim's death. And more importantly, that we've shown that the operation of the vehicle was the proximate cause of death. That was the direct and natural result of operating the vehicle. Operating the vehicle in this way was not braking while going left of center into oncoming traffic and striking a tree. Clearly reckless driving in this case, Your Honor. And so ultimately, the people have shown to the probable cause standard that a crime occurred, that the defendant probably did it. We've shown that for each of the elements of the two charges alleged, Your Honor. And if the court is not necessarily inclined to bind over, the people would remind the court that even if, with some of the questions that defense counsel asked of Detective Bessel, inquiring about issues with the vehicle, with medical emergencies, with potentially defective equipment in the vehicle. There's no evidence to support any of these claims, but even if the court were to credit them, it would be a question of fact or trial of fact determined. Thus assuring the bind over.
Opportunity to listen to the prosecutorial witnesses and examine the exhibits, people's exhibits 1 through 10. There is a question of the fact that it says this is a probable cause hearing and the prosecution has met that burden. As such, the matter is going to be bound over to the circuit court, wherein the burden of proof is going to rise significantly and substantially to beyond a reasonable doubt. The prosecutor is going to be held to that much higher standard by Ms. Longstreet, and I'm confident in that. The AOI date is going to be August 9th.
August 9th.
August 9th, 09 at 9 a.m.
Thank you.
Thank you very much, Your Honor. Your Honor, may I approach and recover the exhibit?
Yes, Mr. Clerk has them. And can I see Mr. Beamers and Ms. Yafuki on a separate unrelated matter?
I'll get you later.
Calling case number 2056145, People versus Eric LaShawn Bell. Defendant is charged with count 1, controlled substance, delivery or manufacture, methamphetamine. Count 2, controlled substance, possession of methamphetamine or ecstasy. Count 3, operating while license suspended, revoked or denied. Defendant is a habitual offender. Third offense notice. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Yakupi on behalf of the people.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Services of Detroit, P 31383, on behalf of Mr. Eric Bell.
Good morning to you, sir. Could you state your name, sir?
Eric Bell.
Thank you. Today is the date and time set for preliminary examination. Mr. Washington?
Your Honor, I've had an opportunity to discuss this matter with Mr. Bell. I advised him of his statutory right to have a preliminary examination. After being so advised, Mr. Bell wishes to waive holding that.
Is there any objection to the proposed waiver?
No objection, Your Honor.
Thank you. So, Mr. Bell, I just need to ask you a few questions. Do you understand the allegations against you, sir?
Yes.
Do you understand that you have a right to a preliminary examination?
Yes.
Do you understand that if an examination did occur, that the prosecutor would need to establish by a probable cause standard crimes were committed in the city of Detroit, County of Wayne, and that you probably committed those crimes?
Yes.
And do you understand that if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings? Do you understand that process? Pardon?
Yes.
Thank you. Your attorney has indicated that you wish to waive your right to a preliminary examination. Is that true, sir? You understand that that would mean that this matter gets bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Correct.
And is that what you still wish to do? Okay. Are you doing so voluntarily, sir? Pardon?
Can you repeat that?
Are you doing so voluntarily without
Yes.
threats or coercion?
Yes.
Thank you. That being said, I just need your signature and your attorney's signature on this examination waiver form that I handed up to Mr. Clerk. The matter is going to be bound over to the circuit court for further proceedings with an AOI date of August 9th at 9 a.m. Anything further?
Nothing further, Your Honor.
Thanks,
Thank
sir.
you.
Thank you, Your Honor.
Were you able to get in touch with anyone?
I left a message for, Ms. Burton. Mr. Upshaw is on the record next door. He's gonna come in when he finishes.
Okay. And what about the Thurman?
It's a whole, I'm gonna get part of that.
Yeah, 30 minutes.
Okay. Officer Williams?
Right here, so we just need to combine.
Oh.
I would just call it, if they, I would just call it. Mr.
Call it now?
Call it now.
Okay, calling case number 2057106, People versus Sean Thurman. Defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, firearms, and larceny. Count 3 and 4, weapons, stolen firearms. Count 5, domestic violence, second offense notice. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for an examination.
Okay, before we proceed to this matter, I just want to recall one matter. Can I have the Burton's file, please?
Okay.
Wait, I'm sorry. Who is he?
Torian Johnson.
What case was he on? Pardon? Yes.
That was his Maribel's case. He has a 10/20 and 9/30 example.
Okay, sir, I'm not sure if you were here earlier or not, but you already have an exam date. Your attorney was here. Mr. Sanders, can you tell him again what that exam date is?
October 20th at 9:30 in person.
October 20th at 9:30 in person. Okay, we're back on the record. Oh, yes? We're back on the matter.
Yeah, Carl about the law back on because she wanted to.
Okay, thank you. We'll recall it. We'll recall it. People versus Jackson, we're on, no, strike that. People versus Thurman. Sean Thurman, appearances, please.
Jacob Bloomers on behalf of the people. Patrick Ninehigh's P76323 on behalf of Mr. Thurman, who's present in the courtroom today. Sir, can you say your name, please?
Sorry.
Thank you. Any preliminary matters before we begin?
Just briefly, Your Honor, I have what is marked as People's Proposed Exhibit 1. This is a register of actions from the Third Circuit Court. It is case number 00-009-705-01-FC, which shows that the defendant, Sean Thurman, was convicted of assault with intent to murder on December 20th of 2000, and is thereby ineligible to possess a pistol.
Have you had an opportunity to view that?
Yes, Judge, and the only issue I have is that it says Thurman without a D, so I don't know if that.
Does all other information add up and coincide?
Yes, Judge.
I am going to allow it over that. I'm not sure if that was an objection or not, but I am going to allow the admittance of that as people's, I'm assuming it was marked as 1.
Yes, Judge.
People's Exhibit number 1. Are there any other preliminary matters?
None from the people, Judge.
Just to ask for an order of mutual sequestration, which is being accomplished right now.
The pandemic has already effectuated that in terms of the COVID restrictions that are still in place. There are no spectators here. The Zoom gallery only consists of one other individual who's here with his attorneys waiting for his case to be recalled, and the rest of the people in Zoom gallery are working in court. The third tier to sequestration is that this is live streaming on YouTube. So if there's anyone watching the live stream that is a witness or a potential witness, you should now stop from watching to maintain the integrity of this process. I will just note that it's now 12:03, 12:04, we do a hard stop at 12:30. What we don't finish, that's fine, you'll just get a new date. Please call your first witness.
Your Honor, the people called Kiva Jackson.
Ms. Marable?
Yes.
You could call Mr. Clerk and let him know why we need to recall this matter, that'd be great. 965-2282, and we'll make sure we have the appropriate prosecutor, et cetera.
Okay, 2282, and I did talk to the prosecutor. Thank you.
Oh, thank you. First witness? Good morning to you. Could you please state your full name and spell your first and last name, ma'am?
Yes, ma'am. It is Kiva, K-E-V as in Victor A, and my last name is Jackson.
Thank you so much. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, ma'am. You can make your way over here. There's a little half gate that will open up towards you.
Okay.
Watch your step coming up those stairs
Okay.
and have a seat. Mr. Prosecutor, when she's settled, you may proceed.
Thank you. Good morning, Ms. Jackson. Could you please state your full name for the record?
Yes, it is Kiva Jackson.
And Ms. Jackson, on or about the date of February 2nd, 2020, were you at the address of 20131 Maross?
Yes.
And is that in the city of Detroit, County of Wayne?
Yes.
And how do you know that address?
That's my home.
Okay. What exactly happened there that brings you here today?
Sean had come over that night.
Okay,
And-
I'm just gonna stop you right there.
Okay.
Okay, so you say Sean had come over that night. Who is Sean?
His Sean Thurman.
Sean Thurman, and do you see Sean Thurman here in the courtroom today? If you need to stand up, that's okay.
Yeah, sitting there with the suit on, I guess. I can't tell with mask.
Do you need him to lower his mask?
Yes, that's Sean.
Could everyone in the courtroom please lower their masks if
That's Sean sitting over there.
let the record show that the witness identified the person as the defendant?
The record will so reflect.
Okay, and how do you know Mr. Thurman?
Sean was a friend of mine
Okay, how long have you known him?
since 2010.
Okay, so you were at this location, Amaras, and you say that Mr. Thurman came there. What were you doing when he arrived at the house?
I was half asleep, laying on my couch.
Okay, and you recall about what time of day this was?
It was in the evening, maybe about 9:30, 10.
Okay, it's fair to say it was at night?
It was at night, yeah.
Okay, and how did you know that Mr. Thurman had come to the home?
Because when I was laying on the couch half asleep, I heard him, Kiva, calling my name. And then the next thing I'm sorry.
Okay. And so you heard him calling your name, and what happened next?
He was in my house.
Okay, Was your door open or shut at this time?
It was cracked open.
Okay. Why was the door cracked open?
Because I get hot, I just put it that way.
Okay. And so you say he was in the home?
He came in the home.
Were you expecting him at that time?
No.
And did he live at that address?
No.
Okay. So what happens after you find him in your home?
He came into my home and he said, what's up? And I said, Sean, what you mean? He said, what's going on? I said, what do you mean? He said, where's the door? I said, where's always at?
Okay. And after you replied to him, what happened next?
He walked back towards the bedroom, because I only have one bedroom in that home on the first floor. And
well, I'll just stop you there.
Okay.
So you said he asked where the gun was at, correct?
Mm-hmm.
And you said it was where it's always at.
Mm-hmm.
Where did you keep the gun?
In the drawer, in that bedroom.
In your bedroom? And you said that was the only bedroom?
Mm-hmm. On that floor. Mm-hmm.
Judge, can you instruct the witness to answer yes or no?
Yes.
I'm
please.
sorry. Yes, I apologize for that.
So, when had you last seen the gun prior to Mr. Thurman showing up?
That evening, before I went to sleep.
Okay.
Before I was falling asleep.
How did you see the gun?
I put it there.
Okay. How regularly did you handle that gun?
Every day.
Okay. Was this going to be carried on you?
Yes, I carried it on me.
Okay. So you said you saw it last that day when you put it away?
Yes.
Okay. So you saw Mr. Thurman go back towards the bedroom?
Yes.
What happens next?
He asked me who in the fuck clothes was that?
Okay, and what was he referring to?
There were some clothes, men clothes in the bag.
Male clothes?
Mm-hmm.
Okay. And what happened after that?
I said, Sean, we're not even about to go there. He came back out from the room, and he asked me again, what the fuck? You fucking this nigga? That's what he said to me. I said, Sean, and he hit me in my mouth.
Okay. And what happened after he hit you in your mouth?
We were arguing a little bit, and he said he was sorry, whatever, and we talked for a minute. He left.
He left? Okay. And
Is that a yes?
I'm sorry. Yes, I know better than that. I'm sorry.
okay, and so after he left, what did you do?
I went to my back room.
Okay.
To check to see if my gun was there.
And was the gun there?
No, it was not.
Okay. Did you at any point see Mr. Thurman with the gun?
I didn't see him with it.
Okay. And did you report this to the police?
Yes, I did.
Okay. Did you do it that night or?
I did it the next day after I got off of work.
Okay. And did you at any point after that incident locate the gun anywhere in your house?
No.
Okay. And did you speak with Mr. Thurman at all the next day?
I sure did.
Okay. And what was the nature of that conversation?
He called. He told me he was sorry. No, I take that back. When he first called, he was upset, told me he was going to fuck me and my fiance up. Next call, because I talked to him more than once that day, I was at work. The next call, he was crying, saying it hurt so much, you don't know how that feels. And he said he was going to shoot my fiance in the face.
Okay.
And I kept telling him, Sean, just bring my gun back. He told me he was going to put it in my backyard under my barbecue pit. Never put it under it.
Okay. Do you recall that exchange happened before or after you went and made the police report, if you recall?
The conversation?
Yes.
It was before.
Okay. And did you ever find the gun there under the barbecue pit?
No.
Okay. Was the gun ever returned to you at any other point?
No.
Okay. No more questions.
Cross-examination.
Thank you, Judge. Okay, Ms. Jackson,
Yes, sir.
I'm gonna ask you some questions. If I talk too fast, let me know. If you don't understand it because I mumble, let me know and I'll try to rephrase it, okay?
Yes, sir.
Thank you very much. So you've known Mr. Thurman since 2010?
Yes.
And this happened on February 1st, 2020?
I don't think it was I thought it was the third or the
Okay.
second.
Okay, thank you. So, oh, maybe it wasn't, sorry. So then, this happened around 9:30, 10 o'clock.
Somewhere around there. I can't say the specific time because I wasn't looking at the clock.
Right, so you were watching TV or something and fell asleep on the couch.
I wasn't completely asleep. I was falling asleep.
Thank you. And when you had the door cracked open to let in some cool air.
Yes.
While you were laying on the couch.
Yes.
And then at some point, Mr. Thurman came over.
Yes.
And yelled to you.
Yes.
And then at that time you woke up?
Yeah, I wasn't completely asleep.
Sorry, got up from the couch?
I didn't get up from the couch. I was still laying.
Okay. But then Mr. Thurman comes into your house?
Yes.
Through the front door?
Yes.
Which you left open?
I didn't leave the screen door unlocked.
Okay.
I just left the front door cracked.
Thank you. Was the screen door locked?
Yes.
Okay. And then Mr. Thurman comes in there and asks you about where your gun's at, et cetera.
That wasn't the first thing he asked me. He asked me what the fuck what's going on with me and my fiance.
Okay.
And then he asked me where my gun was.
Okay. And then you said where your gun always is.
Yes.
And then Mr. Thurman leaves would you say you were in the living room?
Yes.
So he leaves the living room?
Yes.
And walks back to your bedroom?
He was, as he was talking to me, he was walking towards the room.
Okay, thank you. And as he's walking towards the room, you're still on the couch?
I'm still on the couch, but I'm sitting up.
Okay, so now you're sitting up on the couch? Is that a yes?
I'm sorry, yes. I'm sorry.
No worries. We're all getting used to this again. So after he walks into your bedroom.
Yes.
And you don't get up and follow him?
No.
Okay. And then he starts asking you about some clothes?
Yes.
Okay, and then he comes back to the living room?
Yes.
And that's when you see him again. Do you see him leave the room?
Yes.
Okay. And when he leaves the room, he talks to you again?
Yes.
Thank you. Now, you said it was what type of gun was it? Pistol or rifle or a?
Pistol.
Pistol? Semi-automatic,
It was a Glock 44 or 40. It was a Glock something. I can't remember. Glock something. It was a Glock.
Okay.
Black.
Okay, thank you. And that's your daily carry gun?
Yes, it is. I have a license for it.
Right, so you have a concealed pistol license?
Yes, sir.
Okay, thank you. And then Mr. Thurman actually leaves sometime then?
There was a back and forth, with him, and he hit me in my mouth, but yes, he left.
With a fist or with what?
With the open hand.
Okay.
With the open hand.
Thank you. And then at some point he leaves?
Yes.
And the next day you go to work?
Yes.
And then you're finished with work and you go to the police department?
Yes.
And you actually go talk to an officer, Chabies, Chabies?
Yes.
And you tell him what happened?
Yes.
Okay, and then you tell him everything the best you can remember?
Yes.
And you're trying to be as honest as possible?
Definitely.
And give him all the details necessary?
Yes.
Thank you. And then at some point, I think it's Friday, February 7th, 2020, another officer, Officer Nightingale, Nighttingale, you have a conversation with that officer?
I don't remember.
Okay. But did you end up going to the 9th precinct?
Oh, yes. Mm-hmm.
Okay, and you gave a written statement, correct?
Yes.
Okay, and that statement that was a couple days later?
Yes.
So you had more time to have everything come back to you?
Yes.
And then you were as honest as you could be for that statement as well?
Yes.
And then you signed it and then turned it over to the police?
Yes.
Okay. And at some point, you and Mr. Thurman were texting or talking on the phone prior to you going to the police department?
Talking.
Okay, was there text messages?
There were some texts too.
Okay. And at some point, he said he would return the gun and hide it in your barbecue pit?
Underneath the pit.
Underneath the what, sorry?
Yeah, the barbecue pit.
Okay.
Yeah. Yes.
Okay. And, you never found it in the barbecue pit?
No.
When did you check the barbecue pit?
That day I got home from work.
Okay, so before you went to the police
I
department?
checked it even afterwards to see maybe if he might have done it a couple of days later.
Okay, thank you very much. Nothing further, Judge.
Any redirect?
No redirect, Your Honor.
Thank you. You may exit the courtroom. Thank you so much. Any further witnesses for the prosecution?
No further witnesses, Your Honor.
Any witnesses? Mr. Dias?
No witnesses for the defense, Judge. Thank you very much. I appreciate it.
Is there a motion?
Yes, Your Honor. The people, first of all, would move to amend the date of offense from February 3rd, February 2nd, 2020, and then move to find over on all charges and all reserve arguments.
Mr. Dias?
Judge, I'll object without argument.
Okay, I've had an opportunity to listen to the testimony as presented by the prosecution by way of Ms. Jackson here today. This is a probable cause hearing. You should understand that, Mr. Thurman, and the burden on the prosecutor is to establish by probable cause standard that crimes were committed, city of Detroit, county, Wayne, and that you probably committed those crimes. With the presentation of this testimony here today, the prosecution has met that burden. It's a rather low burden. It's not a non-existent burden, but that burden has been satisfied. The matter is going to proceed as charged, including the misdemeanor of domestic violence, is going to proceed forward to the circuit court for further proceedings wherein the burden of proof will then rise to a much higher level, that being beyond a reasonable doubt. Today was not the trial date. This was an examination to determine whether or not there was sufficient evidence for which there could be a question of fact. And a question of fact clearly does exist. So the AOI date is going to be August 9th at 9 a.m. Was there anything further from either the defense or the prosecution?
Nothing additional from the people, Judge.
Nothing additional from the defense, Judge. Thank you very much.
Thank you. Please make sure you abide by that no contact provision, sir.
Thank you, Judge.
Thank you, sir. Mr. Bloomers and Ms. Yabubi, I know that
Absolutely. Got it.
I see Mr. Manable, what about, Ms. Burton? Say she was
I
gonna.
never had her on.
Well,
So what I do is I can schedule a pre-trial in that case and put it out for like 3 weeks.
just send those,
Send those.
they'll just figure
Okay.
it out.
Here, there's the file right there, I think.
Oh, this one?
Yep, that, yeah, I can do it.
Mr. Bloomers,
Yes, Judge.
no worries on, Ms. Burton didn't respond back. And I'm not going to have hanging on indefinitely. We're just going to send a pretrial notification out on that.
Okay, thank you.
Thank you.
Now, I do see Mr. Horton here, so I don't know if Ms. Maribel is gonna.
Here.
Oh, she's here.
I'm here.
Recalling People versus Horton. I don't have the case number. Could you just call it though, while you have it right there?
Yes, calling case number 2159369, People versus Quentin Horton.
Thank you. All right, this matter was already formally called earlier. Appearances, please.
Jacob Bloomers.
Carla, I'm sorry, but thank you. Carla Marable on behalf of Mr. Horton, and I'm sorry that I'm asking you to recall it. I forgot to ask about something that's very important. And I did talk to Mr. Bloomer because I came back and I did tell the prosecutor about this. Mr. Horton, can you state your name for the record, sir?
Quentin Horton.
Thank you.
Mr. Horton has some homes in Mansfield, Ohio that he's redoing, and he needs permission to travel to Mansfield, Ohio to work on these homes. He's the owner of them and he's rehabbing them.
Mr. Bloomer?
Well, I guess, is this like a specific thing, or are you saying just like over the next several months, he's gonna need to be able to go there regularly?
Mr. Horton,
Yes.
are you going?
Yes. Yeah, over like a couple months, because I'm, doing houses all over. So it's just, this teller really put a hold on a lot of my stuff, and I got to be down to make sure workers even there. I might have to frame.
So let me
stuff.
ask this question, Mr. Horton. How many days will you go down to Mansfield, Ohio?
Sometimes maybe two times a week. It depends on what I'm doing, but really one time a week, really.
Okay.
Okay. I mean, I don't have any objection in principle to this. I think we just maybe need something an order in writing. Unless the court.
Let me tell you what my concern is, just like we had a previous case earlier today. These are serious allegations. And so I can't open the floodgate and say, sure, you've got a tether, but go right ahead. And it's already an unrestricted tether. I'm not comfortable with just a blanket okay to go back and forth without having a real grip on the parameters of this, because the reason that the GPS tether was put into place in the first place was to maintain the safety of the community at large, and particularly Miss Gray, Dewanne Gray. But the first prong of the bond analysis, on which I really have no clue as to whether or not there's any red flags, is the reassurance that the defendant will return. Now, I'm certain he's been here. I'm certain he will return, but I guess I'm not 100%. And if he's got a reason to be away in a different state, that does cause a level of concern just to have an open-ended sort of situation. So if, Madam Defense, if you can craft a proposed order that delineates the dates, the mode of travel, the departure dates and return dates. That's really the only way that I ever really approve travel. That's not unique to Mr. Horton. That's in every matter that comes before the court. I see Mr. Horton's expression on his face. With every matter that comes before the court, I need the airline I need the flight number. I need the date they're leaving. I need where they're staying when they go there. I need their return flight information. And I can't make an exception for this case, notwithstanding the fact that you say he owns property. Now, what I would be willing to do, if we can't come up with something that makes sense, I'd be willing to bring that date much closer. October is an early date, considering how our docket looks. But given the fact that I'm going to likely, given the fact that I'm not going to acquiesce to an open sort of travel situation, I'll bring that date into August. It's gonna be a tight fit. When I say tight, I mean really tight. You may be in the hallway for a bit, but I'll bring that date into August if you like.
Well, let me do this, Yana. Let me talk to Mr. Horton, right? Because only thing you're saying is that before you allow him to travel, you want the dates. So Mr. Horton is rehabbing these houses. He would me and him would have to just sit down and figure out, are you going to go every Wednesday? I know he said he's going to drive his car. We can give you the address. He's going to be at the address between such and such time. So we may be able to work it out. Let me talk to Mr. Horton, and then if I'm able to work it out, I will do an order, send it to Mr. Bloomer, and then if not, we'll be back.
And if not, I'll give you, like I said, I'll give you an exam date that second week in August. It just is going to require you to pack your patience. And Mr. Horton, you can speak with your attorney.
Let me talk to Mr. Horton, and I will be back with you, okay?
All right, thank you. Okay, calling people versus Jaquan Scott, 206-058801.
Thank you, Yana.
Thank you. Well, let's call it, but since you have the file.
Calling case number 2060588, people versus Jaquan Scott. Defendant is charged with count 1, homicide, murder, first degree premeditated. Count 2, assault with intent to murder. Count 3, assault with intent to do great bodily harm, less than murder by strangulation. Count 4, failure to stop after a collision. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
And good afternoon, Your Honor. Elizabeth Dornan, appearing on behalf of the people, P79420.
And good afternoon, Your Honor. May it please his honor, the court. Richard Taylor, P number 55237, on behalf of Mr. Jaquan Scott, who stands to my right.
Okay, good afternoon to you as well. Could you state your name, sir? Thank you. So today is the date and time set for examination in this matter. Since we were last present in this courtroom on this matter, there has been a change, correct, Madam Prosecutor?
Yes.
To the complaint? No? Isn't that why we're back?
Yes,
Okay.
the complaint now alleges, as instructed on remand, to add count 1, first degree premeditated murder. At the last hearing, we were, a few weeks ago, I did provide to the court the medical examiner's report as an additional piece of evidence in this case.
Yes, and I've also had an opportunity to review the transcript, and that was taken on, looks like Tuesday, November 24th. There are some other exhibits that were contained in this file that I had. I want to make sure that I get those back to you, so please make sure you have that, including the medical examiner's report, as there would be no reason for this court to hang on to it. The medical examiner's report, I do not believe was marked and admitted. If it was, great, but if not, as a matter of housekeeping, I think it's important that we just make sure we're all on the same page.
And I believe that I had marked it, Judge, but
Well, marked, yes, but has it been admitted?
Well, Your Honor, could you tell me, Your Honor, is it exhibit number 9?
5. Wait, medical record, hold on.
It should be
9, yes.
9. At this point, then, Your Honor, I would move to admit that under court rules which allow a medical examiner's report.
I'm assuming you've had an opportunity, Mr. Taylor, to lay your eyes on this, correct?
I've had an opportunity to review it, did provide a copy to my client, so we don't have any objections to the addition of the medical examiner's report at this time.
It will be admitted as People's number 9. And how else would you like to proceed here today?
Your Honor, with regards to this particular case, I would just ask, since the only count at issue for the court at this time is count 1, I would ask the court to bind over with regards to count 1. I'm happy to make an argument now if the court would like.
Well, I think let's hear what if there's an argument opposing it or not, and then we'll go from there.
Obviously, I would, there's an argument opposing as relates to binding this matter as relates to a first degree murder charge.
Wait, I'm sorry, could you use there's the only microphone is at the podium.
I'm
Thank
sorry,
you.
Judge. Again, Judge, obviously, I would oppose to binding this matter over to it as it relates to a first degree murder charge. Obviously, the court has, I don't know if the court wants to prosecute or allocute as relates to that first before I.
Why don't we do that? Well, I want everyone to understand, I'm like right up to speed with everyone. I'm not stepping into this like with, you know, a mindset that I have no clue of what you're talking about. But we have to make a record, which is why I'm asking for certain things to be done and placed on the record and exhibits to be admitted if they weren't already admitted. Why don't we just start from scratch? You make your motion in full and then let defense counsel respond, and then you can use a rebuttal time if you'd like.
Okay, thank you, Judge. And as I just indicated, Your Honor, I would ask the court to bind over with regards to count 1, first degree premeditated murder. With regards to the premeditation in this particular case, there's a couple of things that I think speak to this, and they're as follows. We have a fender bender. And in the fender bender, Mr. Perry, who was driving a Chevy truck, gets out of his vehicle. And the defendant, who's driving a white, either a Ford Taurus or the Mercury version of that car, drives past the scene after being in the car accident. And then he comes back. Then the defendant proceeds to get out of that white vehicle. And he has a plan when he gets out of that white vehicle, and it's obvious that he has some sort of plan because the video evidence in this case shows that the defendant gets out of the driver's seat of the vehicle. The passenger in that car moves over and drives the car away. Meanwhile, the defendant crosses the road, stomps back over through an intersection, and comes up to Mr. Perry. Mr. Perry, as those records indicate, is a senior citizen. He is not a young man. And Mr. Perry, who is examining his truck, starts to get into argument with the defendant. Ms. Main testified that there were words exchanged during that altercation. However, the defendant then proceeded to take a swing and effectively punch Mr. Perry. That first punch of the defendant lands Mr. Perry on the ground. After that first punch, there are 4 more swings and punches at Mr. Perry, who is now on the ground. Then the defendant stomps on Mr. Perry's head 3 times.
Yes, no, sir, you can't speak up. You can't talk to yourself.
Or 2 times, excuse me, I said 3, it's 2 times. The fact that the defendant repeatedly struck Mr. Perry while on the ground and then stomped on his head. We're not talking about him stomping on his leg, his ankle, his foot. He's stomping on his head. That speaks to premeditation. It speaks to every single time he could have stopped and taken a second look. Every single time. He could have drove on by and left. He could have stopped at the yelling. Look, it's a car accident. People get in car accidents all the time. People get upset about car accidents. Understandably so. But he then proceeded to take it to a different level. And he punched Mr. Perry. And he could have stopped when Mr. Perry fell to the ground after the first punch, but he didn't. No, the defendant kept going. He doesn't stop until Mr. Perry is unconscious. Case law is clear that mere seconds can be sufficient for premeditation. In this particular case, Judge, there were several minutes, in my opinion, of premeditation. The car accident happened approximately a minute and a half before Mr. Scott returned to the scene. And then the assault of this particular case went on, as I've just described, for 7 different incidents. Well, there is, and obviously the court is aware of the intervening time between the assault and Mr. Perry's ultimate death. That is really inconsequential in this case, because the fact of the matter is the medical examiner ruled Mr. Perry's death to be from blunt head trauma. And it's obvious the only person that caused that to Mr. Perry was in fact the defendant. The defendant unlawfully injured and started a series of events that naturally resulted in Mr. Perry's death. So with that, Judge, I would ask the court to bind over with regards to the first-degree murder. I appreciate your time.
Thank you. Mr. Taylor?
Thank you, Your Honor. And although I appreciate the argument of the prosecutor, and obviously the court has had an opportunity to not only listen to the initial preliminary examination, and although I was not the attorney that was part of that initial preliminary examination, and the court has had an opportunity to read that preliminary exam transcript, but I don't know whether or not the court had the opportunity to review the video that was taken from the gas station in which this incident took place. And again, as I appreciate Sister Counsel's arguments, Your Honor, it does not, and the court is well versed in these situations. And I understand that this is simply just a probable cause here. But nevertheless, given the situation and the circumstances, this is what we would characterize nothing less short of a simple road rage type incident. And in terms of Sister Counsel exaggerating the level of physical contact that my client, Mr. Scott, had with Mr. Perry, I don't believe that given in that moment and given in that instance, obviously there was a verbal altercation between my client and Mr. Scott, and I'm sorry, Mr. Perry. And although I understand what the law is in that sense, in terms of what a verbal altercation can escalate into in terms of provocation as relates to an assault. But there's not a clear cut as it relates when you're looking at the video in terms of any physical contact, and obviously Sister Counsel can argue differently if she chooses to, but it's a matter of what a person sees and perceives when they look at this particular video in terms of any physical contact between Mr. Perry and my client. And Your Honor, it goes to bode well, again, we're talking about a physical assault. Mr. Perry goes into a coma, and it was in a coma for several months before he passes away. So in that sense, Your Honor, do we get to a position of even at a probable cause standard of relates to premeditation? I understand that it doesn't take long, the time frame for someone to act when they act, and then in turn, what their thought process may have been prior to acting in this situation, and that those circumstances ultimately leading to someone's death. I understand that. But in this instance, it's clearly not a situation of premeditation. Clearly, the coroner ruled this as a homicide, blunt head trauma. Understanding, again, looking at the medical examiner's report, that Mr. Perry had suffered from a number of ailments as well. And clearly, I know the law, and the court is well versed, I apologize, in terms of the law, in terms of taking a person as you get them at the time you see them. But nevertheless, I don't believe that those ailments cannot be ruled out as a contribution. And although the coroner did indicate that his homicide was based on blunt head trauma, clearly it is not the brutal nature in which the prosecutor has described in terms of what took place during the course of that incident, in terms of the blunt head trauma that led to Mr. Perry's, ultimately, has been ruled to lead to Mr. Perry's death. So in saying that, I believe, given the circumstances of this case, given the facts, that at least at a probable cause standard, this does not rise to the level of premeditation, where it's a first degree homicide. And quite frankly, I would even argue now that we have a new petition in this matter, new complaint, as to whether or not those underlying charges that were initially set forth should carry over as well, because they were attempted, and those were all based on the fact that Mr. Perry was still alive at the time those charges were brought. So, Your Honor, I would respectfully ask that this court not bind this matter over on the first-degree homicide charge. Obviously, again, there is a death here, so we cannot deny that. But nevertheless, given what the prosecution is asking under these circumstances, this is clearly not premeditation or done with malice, aforethought. So I would respectfully ask the court not to bind the matter over the first-degree murder charge.
Okay, Madam Prosecutor, do you need to respond?
Yeah, I don't have anything else to say. I would just rest on my argument. Thank you.
So this is not a trial. I know you know that because you've got an excellent attorney sitting here on your behalf. You know this is not your trial date, correct?
Yes.
Okay, this is an examination. The burden on the prosecutor with this new added or amended count 1 is to establish by probable cause standard of crime was committed, city of Detroit, county of Wayne, and that he probably committed it. Now, this is not your typical examination, right? Because we haven't heard from the witnesses today, right?
Yes.
They've already testified under oath. And there was already exhibits that were admitted, right? It would be addition of exhibit number 9 today. And the transcript has been provided and has been read and reread by this court as if this testimony was heard today.
Yeah.
So I'm taking all of that into consideration, just as I would have on the date back in November when you were in here for, or I think it was on Zoom, for examination. And the burden is still the same for the prosecutor. And based on the change in the complaint to that count 1, I'm now considering the medical examiner's report, which is the only newly admitted exhibit, and the question of premeditation. And your attorney, who's again an excellent attorney, his argument is that this was simply road rage gone bad. And I have to respectfully disagree. There is a question of fact that exists here as it relates to count 1, premeditation. As you've heard Madam Prosecutor say, and your attorney will advise you in the same manner, premeditation is not something that an individual, in order to rise to the level of premeditation, someone needs to sit at home the night before and map out a plan, a strategic plan for which to carry out. That's not the confinement of premeditation. Premeditation, as the prosecutor has indicated, can be developed rather quickly. And taking into consideration the video, the transcript of the testimony that was laid out, yeah, there was a short period of time. I do agree with that. There was a short period of time from the accident to you turning back around and confronting Mr. Perry. And then an altercation, a physical altercation ensues. And then Mr. Perry's head is being stomped on by yourself.
No.
That was a rather quick period of time in which all of this happened. But the testimony has come out, the testimony has been reviewed again by the court, and there is a question of fact that exists with regards to the issue of premeditation. We know that Mr. Perry is no longer here with us. That's not the issue. The issue is premeditation. And the question of fact exists. This is a district court wherein the burden is probable cause. It's not a non-existent burden, but it is a much lower burden. Many people come in here and say they don't like how low it is. And until the laws change, it is a threshold, a term of art that we often use, probable cause. It is a threshold that has to be cleared by the prosecutor. And I would be remiss if I did not, under circumstances where it's warranted, permit the prosecution to have the matter heard and cross the street. wherein the burden of proof rises significantly to beyond a reasonable doubt. That is when it proceeds to trial, that is when a trial would occur. And that is when that burden, which your attorney will certainly hold the prosecutor to, raises significantly to beyond a reasonable doubt. With that being said, the matter is bound over. The AOI date is going to be July 26th at 9 a.m. Is there anything further? Nothing from the people, Judge?
Yeah, I guess I would be remiss in my responsibilities to Mr. Scott. And although I understand what the court is binding this matter over, if the court would not take in some consideration as relates to the length of time he's been in custody, in terms of his bond in this case. I think I made the argument previously, and I would just respectfully ask the court to take those items into consideration, particularly, again, the length of time that he has been in custody. He's been in custody through COVID. He survived that, despite whatever his physical ailments are that have been conducive to him contracting it and being seriously ill. He has survived that within the Wayne County Jail. He does have a tremendous amount of family support. I'm in constant contact with his family. I do believe, if I'm not mistaken, that he was actually employed prior to him being incarcerated on this particular matter. But again, Your Honor, and I will say this, despite the unfortunate passing of Mr. Perry, and despite the nature of these charges, I do believe that Mr. Scott can conduct himself in this community in a safe way and not be a threat to the community. So I would respectfully ask, and again, I would be remiss if I did not ask this court in reference to Mr. Scott's bond.
So the court, whenever there's an issue that's being raised regarding bond, I have to analyze a couple different things. Number one, will the individual return to court? I don't know if at one point there must have been a DSU report, but they tend to dispose of those rather quickly. I don't know if anyone has that at their fingertips for which it might provide information about a failure to appear history, if one exists or doesn't exist. My main concern is the safety of the community. So now it's been bound over on that most serious charge, in addition to the other counts that were already bound over, on an incident where there was an accident. And then there was a doubling back and a confrontation that turned physical, wherein a man ends up on the ground with his head being stomped, and since then has expired.
Why does it keep saying it?
And the issue of the safety of the community is absolutely on this court's mind. I have heard nothing, to no fault of your attorney, but there's nothing on this record that would make me feel comfortable in amending the bond unless I were to just put a blindfold on and say, I'm not going to worry about the safety of the community. And I'm not willing to do that. When I come in here and I zip up that robe, there's lots of things that are asked of me, and I can't satisfy everyone. My commitment is to make sure that I'm making determinations that are in line with the safety of the community. If it were appropriate to amend your bond, I would. But at this juncture, with it now having been bound over on first-degree murder, along with the other charges, I am not comfortable at all with amending the bond. Unless Madam Prosecutor is acquiescing to amending the bond. No, Your Honor. Okay.
Thank you.
Let me see one thing. I can take them straight down. Straight down. You go to the side.
May I approach and collect that?
Oh, yes. You can take that note off from Tammy that the date and whatnot. That should all go back under. Thank you, sir. Hello.
Hello.
Hello. What are you here on, ma'am?
Hi. For Jaquan Scott, I might have missed it.
You just missed it. We just finished it.
Okay. Okay, thank you.
All right, thank you.
Okay, bye-bye.
Have a good day.
You too. Have a good evening.
We're all set, correct?
Yep, we're all set. Thank you so much.
Have a good evening. Good morning.
Yes, ma'am. Well, Madam Prosecutor,